Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention to the Shanna Gardner Mario Fernandez trial out of Jacksonville, Florida. They are accused of conspiring to delete Shanna's ex-husband, Jared Bridegan. And trial is coming up in August for Mario and then September for Shanna. And we are going to be looking at some hearings that have happened, some this week, some a few weeks ago, and then also one hearing with Henry Tenon, who is the alleged shooter. So sit back, get comfortable, and let's get started. All right, welcome in, everybody. Welcome in. Thank you for joining us. Who is with us today? Really appreciate you guys coming on over from the sentencing of Colin Gray. You guys found your way here. I appreciate that. We have Karen in the house from Germany. Hello, hello. Welcome in. Hey, Camilla, Sherry, Bing and Billy. Good to see you. Shirley Roth. Good to see you. Hey, Brett. Howdy to you. Elaine got here safely. Kaylee. That was a short runway landing. Horse Welfare, how are you? Shannon, good to see you. Jenny Lynn, welcome in. Debbie, hello again. Amby, Melka, good to see you. Thank you for joining us. Missy Russell, how are you? We have Quilting Girl in the house as well. Missy saying, Abe is there. Hey, Abe. Scent Bunny. Landed safely. Good to hear that. All right, let's see. There's Abe. Let's see, who else do we have? Oh, Green Eyed Cat. Hello. William, great to see you. Crazy Mary Fitz, parachuting in. Christine, how are you? Virginia Kimbler, here we are again. Just to go baking, I'm refreshed and ready to go. I'm actually melting. It's 89.7 in the office, but we have AC coming tomorrow, or our motor is being fixed tomorrow afternoon. Heidi, hello, welcome in. Snake Lady, how are you? Great to see you. Brenda, Shelly Beans, welcome in. Pork Butt Chain Smoker, how are you? The Pretty Chick, wow, it's been a minute. How are you doing? Sandra, wasn't sure if we were live. Thanks for doing this. Yes, we are live. We are live. Anna, welcome in. Great to see you. All right, Misbehavin', reached from UK, smushed your DNA. Play on Crime, glad you made it over. Pippi, welcome in. All right, so let us, did we get some sleep in the cool air last night? Sherry, I did from 11 until 4, and then Rafa and Super Ball started to fuss with each other, and I didn't fall back asleep. So I've been up since like 3:45. But I'm very happy that we have a... Our Our AC will be fixed tomorrow afternoon between 12 and 5. So happy for that. All right. Let's do a little recap. So we have done a couple streams on Florida versus Gardner and Fernandez. All right. So we got Jared Bridegan. So he's the victim. He was 33 when he was taken out. And Shanna Gardner is one of the defendants, and Mario Fernandez Saldana, they are the defendants. Now, Shanna and Jared were married at one point. They had kids. They got divorced, and Shanna and Mario got together. I don't believe they had any kids, and now they're divorced. So this happened on February 16th, 2022. So Shanna and Mario, they're charged with ambush deletion of 33-year-old father Jared Bridegan, who was gunned down February 16th after stopping to move a tire intentionally placed in the road. So he's on kind of this dirt road, back road in Jacksonville, and he stops. There's a tire in the road. He stops, gets out to remove it, and he's taken out with a firearm. Now, the alleged person who did that was Henry Tenon, and we're actually going to start off with his, because he originally pled guilty, but then he's changed his plea to not guilty. So he's an interesting character as well. So Bridegan and Gardner were married and they had 2 children together at the time of his passing. The 2 were involved in a long-running and contentious custody dispute, which prosecutors allege played in part of this attack. Now, Bridegan's 2-year-old daughter was in the car, so he got remarried, right? And then he had I think twins. So his daughter was in the car at the time, but so Kirsten is her name, and we're going to do a hearing on her text and her phone. So that's part of today that they want to bring her texts into the trial. So we'll tackle that when the time comes. All right, so then Fernandez was arrested August 2nd of 2023. Gardner was arrested the following day, August 3rd, 2023. Both are being held without bond, and if convicted, they do face life without parole. And here in Florida, life without parole means life without parole, no possibility of parole. So let's start with Henry Tenon. I mentioned his name, so let me put myself up here. All right, so Henry Tenon is the gentleman who is alleged to be the one who pulled the trigger. He's the trigger guy. So he originally pled guilty, and then he changed his plea. So let's get to it. Now, this happened on June 19th, and we're going to listen to a couple more, June 12th, June 21st, June 26th, June 27th. So we're going to start with June 19th. So this is Henry Tenon. Oh, and before we get started, Judge London Kite, you guys are going to love her. Judge London Kite, she's fantastic. You guys, if you haven't watched any of these pretrial hearings with us, I hope that you are as much excited about watching her, listening to her. She's a fantastic judge. Absolutely love Judge Kite.
Good morning.
And good morning, Your Honor. Julie Schlacks appearing on behalf of Mr. Henry Tenon.
Good morning, Mr. Tenon. Good morning. All right.
Your Honor, we are here to set this matter for trial. The court had given us some ideas of availability. I spoke with Ms. Schlacks, Mr. Mizrahi, and Mr. Cooper about the other case, and we've agreed upon, if the court's amenable, jury selection beginning March 29th, 2027, with trial to commence that week and into the week of April 5th.
Why so far?
Last time we were here, Ms. Schlacks had some, I think, trial conflicts with some other death penalty cases. She and Mr. Mizrahi has a capital case as well in January or February.
Oh, okay.
And Your Honor, I'll be happy to kind of go through the months. Unfortunately, I have 5 pending death penalty cases, and every judge wants me to go ahead and set a date. I don't know if they're realistic or not, this juncture.
Okay.
Perfectly candid with the court. So I have a death penalty case set for November. That one, I can probably say the most concretely should be ready to go. I have another 2-week non-death but homicide set in January. I have a death case set in February. I now have this case set in March, early April. I have another death penalty case set with the court. I have a further death penalty case set in May. And then I just set the final one for August.
And Your Honor, I did clear the trial date with the deceased victim's next of kin. I also wanted to avoid, for child care issues, school holiday weeks for them. I think spring break is early March.
According to my calendar, spring break is March 15th for Duval County.
They're in St. Johns County, Your Honor. I believe it's either the 15th or the 8th.
Okay. Does anybody else have Duval County spring break issues?
I personally would, Your Honor, but...
Okay, and I do too.
Okay.
Do you?
Do not.
Not anymore.
Not anymore.
Mr. Mizrahi, do you want to join?
That's not happy spring break when I was.
So St.
I
John's,
personally am not going on spring break, but I have a child out of school.
St. John's County is when?
I think it's the week prior to Duval County. I'm not positive on that, Your Honor.
I can look it up.
Okay, and then, so y'all are proposing when?
March 29th and April 5th, those 2 weeks, for jury selection and trial. The trial itself will not be more than a week, but we wanted to build in extra time.
So, Ms. Schlax, did I move gay? Because gay I have the week of April 5th.
And
I said I was going to move it.
Yes, ma'am.
right, and that's why Mr. Cooper was involved.
For the state, Mr. Cooper is the presiding ASA on that case, and we spoke with him as well,
And he's okay with moving
Yes,
it.
Your Honor.
And so was Mr. Fletcher,
Where is he?
Chuck Fletcher.
Where is he? He went somewhere. All right, so he was okay with moving it.
Yes, Your Honor.
Thank you. Mr. Hathaway's on this, he's on it. St. Johns County is March 15th through the 19th.
Okay.
So same. Thank you. All right, so I'll take the dates.
Yes, Your Honor, thank you.
All right, working backwards. Do you think this would just be a week or potentially go into the next week, so 2 weeks? Do you want me to reserve the 2?
I think we can reserve the 2. Jury selection is why we're building in the extra time. If we're able to select a jury that first week, we can begin trial without taking a break and then have that second week to spill over. I built in a week for jury selection and a week for trial with those dates, but we might not need the full week for jury selection.
You agree?
Yes, Your Honor, and we could always revisit it after the.
I'd rather
state
reserve
go
more.
through. Yes.
I'd rather reserve more than less.
Yes.
All right, so, all right, working backwards then. For trial, jury selection will be March 29th, 9 a.m., and that's for jury selection. The trial to commence that week, and also please reserve the week of April 5th. So April 5th through the 9th. Those will be the jury selection / trial weeks. Then the final pretrial. Is there court? There's no court holiday on the 22nd, correct?
Correct. Easter is March 28th.
March.
So court is closed March 26th.
Okay. So March 22nd, 9 a.m., final pretrial. My plan would be, now that we have dates, that I'm going to put in a priority case order and a case management order. So with you all present, I'd like to give you input in that. So do you anticipate, I'd like to maybe handle motions the month before,
Certainly.
like sometime in February,
Yes, Your Honor.
if there's anything.
Wants us to start in January,
Okay.
because with rare exception, I have been able to make the vast majority of all of the depositions that are taking place. I think Mr. Blythe.
I saw that
Only one
list.
that I can identify that I know I will need to redepose, but it's going to be scant witnesses.
Okay. And I did sign an order this week with all the depositions.
Yes.
And so I appreciate that. So tell me what y'all are thinking. I mean, like, we can reserve the time, or you can just let me know when you need me. It's up to you.
I'll be happy to notify the court immediately
Okay.
if we need any kind of motion hearing time.
We did complete one hearing.
Right. Well, what I'm thinking about is, maybe we should I'll just leave it on like status and pretrials. I think that both sides may learn. I think both sides may want to talk about jury selection, logistics, and things like that. So I'll just leave it on a pretrial status, and we can touch base maybe early in the year.
Yes, Your Honor.
When you all want to come back?
Your Honor, if we could come back, I would suggest July 27th.
Did you get all the funds that you needed for like private, was the switch in private investigator affect you?
No.
Did you have Ruta?
No.
Okay.
I always had Ms. Hannon. It's been on the case since the beginning. And I believe the court has signed off on every administrative order and different experts we've sought.
Okay. Is that date okay with the
Yes, Your Honor.
state? You said July 27?
Yes, Your Honor.
See you then.
Your Honor, how many prospective jurors should we reserve?
I'll address that. I mean, do you want me to say a number? I just don't know.
I think we'll be informed
Yeah.
Right.
in August about
What we'll need.
I will. I know that might drive the clerk's office crazy, but I think I'm going to wait, Mr. Hathaway.
It will be fine.
Okay, all right. I'll address it at the beginning of the year. But if the clerk's office, so this is the issue just for the parties, like if there are, this is what I'm kind of talking about. So if there are any special requests, such as any type of post-evidentiary sequestering, the clerk's office needs to ask for the money sooner rather than later. If you all are anticipating things like that, we need to talk about that before when is your budget year end? Or it starts in July, right?
I believe so.
Okay, so we need to, maybe y'all can have some of those discussions, and I can give it a preliminary idea of how many jurors, but if there are any type of special accommodations, i.e., okay, which is what we're doing in Gardner and Fernandez, which is sequestered lunches, like they're not going out, we're catering in, they're not going to be milling around. So if you all are thinking about those same type of things, we need to let the clerk's office know so they can ask for the funds. Okay.
Yes, Your Honor. I'll speak with
Your Honor,
Ms.
our
Schlack.
budget year is the normal fiscal year, it begins October 1st.
Okay. So we have a little bit of time, but I do need y'all to start talking about those logistical things.
And being able to monitor what occurs in August and September will help us.
Correct.
Perfect. Okay. All right. I'll see you on the 27th.
Thank you, Your Honor.
Thank you.
All right, so that's Henry Tenon, and that took place in June. So he withdrew his guilty plea February 17th of 2026. So he had originally pled guilty, and then he withdrew that plea. So now he's going to go to trial in 2027. All right, so now we're going to fast forward to July 12th, and this is about a 24-minute little clip. So I'm going to have to put myself over here because of the obnoxiousness of the logo. All right. Ugh. Oh, another side note is, hold on a second. Let me just play this and I'll find it. Right, so side note is that Jose Baez is representing Shanna. So high-profile case, high-profile lawyer. So Jose Baez is going to be representing. He appeared in one Zoom, and I think he may have been live once or in the courtroom once. But generally, he has other people, other parts of his team representing her. So that's Mario, of course. He came in first. So Jose Baez, as of right now, he's still Shanna's attorney. Seems like I might be able to fast forward a little bit here. There we go.
All right, so according to CRB's session, with Judge Curtis presiding, physical cell phone and electronic device are turned off. There will be no talking about the point session or when the judge is on the bench. May we see it? Morning, Your Honor.
Thank you. Good morning.
Morning, Your Honor.
Good morning.
Christina Siffler, Alan Mizrahi, and Steve Siegel on behalf of the state. We're here on Shanna Gardner, number 9 on the court's calendar, and Mario Fernandez, number 4 on the court's calendar.
Thank you.
Good morning, Your Honor.
Good morning.
My name is Jesse Dreiser. I represent Mr. Fernandez, who's present and sitting at council table, along with Ms. Day, Mr. Hill, and Frank Tassoni, who is appearing via Zoom.
All right. Thank you. Good morning.
And Your Honor, for the record, next of kin is present via Zoom as well.
All right. Thank you.
Good morning, Your Honor. Patrick Crody for Shanna Gardner, who's present for the court. Also, Ms. Nelson and Ms. Medina, counsel, are on Zoom.
All right. Thank you. Good morning.
And Your Honor, since our last...
Wait. Ms. Nelson, can you hear us? Ms. Nelson.
Good morning. I
Okay.
apologize. We're unable to hear the proceedings.
Okay. Can you hear me now? It's Mike, can you come up?
Your Honor, I think it may be on her end because we can hear.
Okay.
I'm going to ask Frank if you can hear us.
Mr. Tassoni?
Yes, Your Honor.
Okay.
Frank can hear us. I don't-
Mr. Carodi, can you message Ms. Nelson and say that she needs to look at her device? Everyone else can hear.
Yes, Your Honor.
Ms. Medina, can you hear?
Yes, Your Honor. I
Okay.
can.
Okay.
Your Honor, we can proceed.
Okay.
Briefer.
All right. So I know that I owe an order on the wiretap, and I just want to clarify. I did deny it, but I just need time to edit. I was in first appearance. I've been in trial. So
That's fine, Your Honor. For the court's information, since our last court date, we have taken a number of depositions. We have depositions, the last remaining ones set for this afternoon. We have depositions for next Friday, the 17th, for Ms. Gardner's listed witnesses. And I think that should conclude the discovery depositions, absent maybe 1 or 2 remaining witnesses.
okay. Does the defense agree?
I think within small numbers or entirely, yes. Meaning there could be a couple that I'm just not thinking of, but we are nearing the end, and it may be that we're done.
Okay. So from Mr. Fernandez, his legal team's perspective, is there anything that we need to do? I indicated that I'm going to go upstairs with the lawyers for logistic purposes, so that I can have, I can answer any questions and also like kind of get an idea of what you all will need in order to try the case. So
The only thing that I would ask is out of abundance of caution that if the state and I cannot come to an agreement regarding this afternoon's deposition, that we get some hearing time on Monday or a to-be set, whatever the court's preference is.
I'm going to do it on Monday. I do have 2 jury selections, but I believe one of my colleagues is going to select for the second one. And so I'm going to move my jury selection to 1:30, and then my thought is I can handle these motions that relate mainly to discovery earlier rather than later, so I would handle them at 11 a.m.
All right, so you want defense counsel here at 11?
Correct.
Yes, ma'am. We'll be here. So this upcoming Monday at 11.
Right,
And
July 13th at 11 a.m., hearing a motion.
And if this gets resolved, if we could just email your judicial assistant, and then you could just give us another past date that you see fit. I do think there's at least a 50-50 shot that we resolve this by tomorrow.
Okay. If you don't need the time, that's fine. I do want to have a final pretrial. I did not set that initially. I'm a little bit hesitant to do it the week before like I normally do. Do you want 2 weeks before? Like the 27th?
Yes.
Yes, and then whatever.
And this is for Mr. Fernandez's case. So his final pretrial will be held July 27th.
And what are you thinking in terms of motions in limine? In terms of like time in between those 2 weeks? I know there's a deadline set because I saw it on my calendar for when they're due, but when were you thinking we would actually hear them?
So you all take priority over anything. That's what the priority order is. So if you need me to handle them, you just let me know and you advance on my calendar. So I'm depending on the parties because you all know the substance of the motions to kind of let me know how much time you need. All you have to do is let me know that and I will advance you on my calendar.
Yes, Your Honor. I'll get with Mr. Dreiser and see what they're going to file, what we're going to file, what we agree upon, and what needs court time.
Right.
Okay, so if you need the time, I'll give you the time. You don't even, all you have to do is ask and I will.
Understood. Thank you.
Okay, but just to be clear, so Mr. Fernandez's case will be passed to July 13th, and it's, let's do it in, do you know, is Mr. Nako, is 407 available
It should be, yes.
next week?
On the 13th.
Yes, so we'll set it in 407 for hearing time.
Yes, Your Honor.
Okay, 11 a.m.
There was one last issue that we had taken up with the court previously regarding an agreement between the parties as to the testimony of a minor witness, minor victim, BB. The parties have come to an agreement. We're going to put it in writing and file it with the court. And the agreement is that the state is not going to call BB as a witness at trial, so we do not need to have any litigation on competency issues. The defense has agreed to the admission of a video from the scene of the minor child and to waive their confrontation and legal objections to testimony by 2 civilian witnesses as to her statements on scene. I'm going to put that in writing as a stipulation, and the parties will sign and we'll file with the court.
Okay.
We also agreed, we're coming to agreements as to certain witnesses that may appear via Zoom. We have agreed that AB, which is the initials of another minor that we expect to testify in this case, will appear via Zoom.
Will appear?
Will appear via Zoom.
She's a listed witness for the defense. Mr. Dreiser intends to call her. Mr. Curated has accepted subpoena service from both the state and Mr. Dreiser for AB with the understanding that her guardians would consent to her testimony in Mr. Fernandez's case via Zoom. So we'll sign a stipulation from both state and defense as to Zoom testimony, and Mr. Curated has accepted those subpoenas.
Okay, so if the stipulation, I want you all to go over, there's a 5th DCA case, I believe, I can send it to you, that you go over that particular case with your clients Mr. Dreiser with Mr. Fernandez, and the state, I'm going to send the copy to you. So this, there's a requirement, if there's an agreement, it's not that big of a deal. However, prior to Zoom testimony, there has to be confirmation that Mr. Fernandez can see the witness can see Mr. Fernandez. That is a main issue, and I don't think that it should necessarily be an issue because of 407 and how it's going to be set up, but all those things have to be confirmed for the record. And then it specifically addressed the confrontation waiver. Okay.
Sorry. And we should be able to take care of that. She's a defense witness, so I don't think.
She's also listed by this.
I think the waiver of confrontation will be something we can take care of.
And then having said that,
It was actually in this courtroom. I think Judge Soud wrote, it was an affirmance, but Judge Soud wrote
Yes, ma'am.
a concurrent opinion that I think gives guidance to any remote technology.
so with that instruction for our future conversations, I just assume that the court, if we had an agreement as to witnesses, you would not necessarily have it.
Yeah,
An
it does not matter to me.
You just want us to make sure we run all those people by our clients so that
Right.
you could do a inquiry if need be.
I will do an inquiry. We can do it, just kind of as a group, but I don't want any issues related to what their rights would be. So if you just, it's an easier process if they know kind of what the law is, and then if they want to waive it, they can waive it. I don't have any objection to remote technology. I think it's the wave of the future, but it just has to comply with, meaning, so I remember substance. I don't necessarily remember names, but I can tell you there are two cases that come to my mind. One is from me, this court, 5th District, a binding appellate court decision. It was an affirmance, but it was instructive how basically the court, one of the judges from the court felt about the confrontation clause. I think it's instructive. Two is that there's another case that comes to my mind. I cannot remember the name, but I will get it to the lawyers, that basically wherever the witness may be, okay, it has to be impressed upon them that this is a court proceeding, that there is seriousness in their testimony, that they understand that the oath, and that they understand that they could be held responsible for any perjured testimony. And so with all of those kind of in mind, when you are setting up your Zoom, when you are setting up your remote, it needs to look professional. They need to know, even if it's a minor child, that this is, an important proceeding, especially on a minor, because, maybe there's a modified oath given, and y'all need to talk about that if you want a modified oath or you want the regular oath, but it needs to be impressed upon them that this is a court proceeding. And so with all of those kind of taken care of and thought about, I don't have any problem with it. You don't ever have to worry that, the judge won't let it. That's not my idea. I just need to make sure that they understand, kind of the seriousness of these proceedings.
Got it. And for Mr. Fernandez, I think that covers it, and then we'll wait until we go upstairs.
Okay.
Thank you.
Your Honor, my understanding is that we also have a...
Come on.
Oh, I'm sorry, Your Honor. Put a microphone. Your Honor, my understanding is that we'll also be here Monday at 1100 for a motion.
Yes. So I haven't seen it yet, but I've heard it's been sent to me. I did read the materials by the defense on the subpoena request, and then I haven't read the state's response, so I will do that.
And then with the agreement related to the minor child BB, I believe it would be appropriate for the court to deny our pending motion as moot related to excluding her testimony.
Okay. Could you do a form order for that, Mr. Hathaway?
Yes, Your Honor.
Okay, thank you.
And Your Honor, while Mr. Carodi is here, I wanted to bring up one small issue. It has to do with the court's order regarding the timing of the filing of the motion in limines.
I can adjust it.
But the state's thought process is we're going to be in trial when their deadline is. So I understand there may be things that come up during the Fernandez trial that causes the defense to file a motion in limine.
Tell me what the overlap is.
It's
What's
5 days. So it's 5 days before the commencement of each jury selection. The state's thought process is some of the motion in limines will overlap, and as practical as we can make it, I would like the Gardner motion in limines to be filed 5 days before the Fernandez motion in limines. So in other words, we can hear them all at the same time. Understanding there may be something that creeps up in the trial that we have to hear, but I don't want to be in this situation where the state's in trial and the defense is filing motions in limine that we have an opportunity to respond to or litigate before the Gardner.
What's the defense position on that? Do you have? I mean, well, let me ask it this way: are there motions that y'all are contemplating that could be filed ahead of the Fernandez jury selection?
Judge, at this time, I can't tell the court that there are any specific motions. I'm sure there will be. We have relied on the court's order, as to that deadline.
Right.
Mr. Wright, he brought it up to me this morning. I'm just not in a position
Okay.
today to address
Can
it.
you talk about it and we address it on Monday?
Yes, sir.
All of you all are very, very experienced lawyers, so I'm hoping that we're not going to be litigating things that are just accepted law. You know what I mean? It should be related to perceived evidentiary issues that are real. You know what I mean? Not boilerplate.
Yes, Your Honor.
Yes, ma'am, of course.
But I mean, to the extent, it's hard for me to do that because when they're separated in that way,
From the state's perspective, having it 5 days before Fernandez, just like the Fernandez order says, doesn't put an undue burden on the defense to have their motion in limine done, 3 weeks before as opposed to 5 days before. I don't think it's that unreasonable. And the same would hold true for the state if we have any in the Gardner case, that we would file it early. I just think if we're going to have motion in limine hearings the week of the final trial, we should do both defendants as much as we can. I'm not going to say that they can't raise something up, but we're trying to comply with the court's order. I just didn't want to be inundated with some motion in limine while we're in trial. That's what I'm trying to prevent.
Your Honor, I can say first that we'll try and file motions as soon as we know we're going to file them. Second, though, I do respectfully disagree with Mr. Mizrahi. When the trials were severed and they were set, that sort of set our preparation timeline as to how we are preparing. I believe that, the additional 3 weeks that we have, we'll work that into trial preparation. So I don't think that we should be held to the same timeline as Mr. Fernandez, who has had ample notice of his deadline for months.
Okay. I'll take a look at it. I'm going to ask the lawyers to take a look at it. Maybe one of the ways to resolve it is you all have been adopting certain motions filed by, Mr. Fernandez's team, and to the extent that it may apply in your trial, maybe that's one way to resolve some of those issues. You see what they file, you can decide whether you adopt it or not, handle it at the same time. But my thought process in setting the deadline the way that it was is that I was kind of told by, you may not take all the time. So there may be time that we are on break or done with the Fernandez trial and we can litigate in the Gardner trial. But obviously, I wouldn't put the state in a position where you couldn't be prepared. I wouldn't be unreasonable. So if you did need the time, I'd give it to you. So I don't necessarily think that is a concern, but maybe one of the ways that you can resolve it, you see what Mr. Fernandez's team files, and then you can see if you want, we can have it kind of at the same time, whether you want to adopt or you're going to let that one, it doesn't apply to your case. And then the state can have those rulings, at least the preliminary rulings from the Fernandez case. But my general thought about motions in limine is like, it's hard sometimes to rule in a vacuum. So some of these things may have to be deferred anyway for proffers and things of that nature. So I don't know what you all are intending, but Mr. Mizrahi, maybe to make you feel better, I would not make you respond to something that you're not prepared for. So.
Thank you, Your Honor.
I just want to bring up the issue also.
All right. Have you all met with IT?
Yes, Your Honor.
Okay. Especially if y'all are going to be using Zoom and things like that. Y'all, the defense team, you've met?
The Fernandez team spent a whole morning following your tour.
Okay.
We met with everybody for ample light court administration.
Okay.
Through all the technology in the court.
Great. All right. Well, so I will see potentially both cases, depending on what y'all's agreement would be. On July 13th, 11 a.m., courtroom 407, hearing on motion.
Thank you, Your Honor.
Yes, Your Honor.
Okay. Thank you. All right. Court's in recess to set up for the normal calendar.
All right, so that was just a bunch of both sides kind of agreeing, stipulating, setting future dates. But I did like the fact that they stipulated that they were going to have the child that was there, the minor that was there. So that was Jared's daughter, as we talked about earlier. She's not going to testify. There was a video apparently of her taken there then, and then there's another minor child that's going to appear via Zoom. So, all right, so let us go to, all right, here's just a news clip. So there was this, these are phone records for her case. This is a news clip, and I want to see if this ties into the next hearing we're going to watch, because the dates are a little bit different.
Well, the widow of a local murder victim will have to give up data from her.
Sorry. Okay, I think, all right, so this does tie into, okay, so we are going to watch this hearing. The dates were different, though, so they must have uploaded them on different, obviously they uploaded them different days. So this is a news clip of what we're going to watch. Oh, come on. So we'll watch this hearing after we watch this news clip.
Well, the widow of a local murder victim will have to give up data from her personal phone for the case. Today, a judge ruled that the defense can subpoena Jared Bridegan's phone. Her husband, Jared Bridegan, was killed in Jacksonville Beach in 2022 in front of their daughter. Investigators believe his ex-wife and her estranged husband hired someone to kill him. Action News Jack's Deja Mayfield is live in downtown Jacksonville. And Deja, this ruling has been a long time coming.
Yeah, Tanika, and that hearing ended as a win for the defense. Today, the court ruled that the defense will be able to subpoena Jared Bridegan's cell phone. It's a decision that took nearly 2 hours today for Judge London Kite to come to. For much of the hearing, the defense and the state went back and forth on their interpretation of a case law that hinged on whether the defense could lawfully request this subpoena. Now, the state argued that the defense hasn't provided enough evidence to show why Bridegan's phone is relevant, while the defense pushed back, saying that they don't have to explain why they want that phone, and also their request is lawful. Take a listen here to a bit of that back and forth before Judge Kite ruled.
We shouldn't be looking through anybody's phone.
I have a duty to my client under the Fifth and Sixth Amendments to not review defense strategy in front of the very witness who would be subject to the cross-examination.
I decided to amend the order granting in part the defendant's motion for leave to issue the subpoena to Ms. Bridegan, and amending it to reflect an in-camera hearing.
And Judge Kite, she granted the defense an amended version of their request. So on Monday, the defense, along with court staff, they will meet to review evidence of Kristen Bridegan's phone. That evidence will be sealed unless the evidence goes to appeals. For local coverage, you can count on Deja Mayfield. Action News Jax.
All right. Now, I'm confused because the next clip I have is via Zoom, so I don't know. Well, let's just keep walking. Let's just see what this one holds for us. Because that attorney was not
For WJX and
So I'm not 100% sure what this hearing is for. This is. It says that it's for text messages, so that's why I thought we were going to see the hearing. But all right, well, whatever. Let's see what this gets us.
WJXT, did you all file any papers or just want to be heard? Okay. I'll take you in whatever order you want to.
I will, Your Honor.
Okay.
So WJAX opposes the proposed closure of the hearing for a couple of reasons, one substantive and one procedural. The procedural one I'll discuss first. Procedurally, Rule 3.220M does not provide for an ex parte hearing relief, except to the extent that a defendant seeks to depose a Category B witness. Rule 3.22M states as following. There are three subpoints to it. The first two are relevant here. The first one states as follows. 1, any person may move for an order denying or regulating disclosure of sensitive matters. The court may consider the matters contained in the motion in camera. And then 2 says, on request, the court must allow the defendant to make an ex parte showing of good cause for taking the deposition of a Category B witness. Those are two distinct subpoints. Rule 3.22M does not provide for ex parte hearings absent the defendant seeking to depose a Category B witness. As the court in State versus Callaway, this is 937 Southern 2nd, 139 explained, quote, the defendant in the instant case suggested below and claims on appeal that Rule 3.22M allows for what is in effect an ex parte in-camera inspection of material. We cannot agree with the defendant's expansive reading of the rule. The rule allows...
Can I stop you for just a moment?
Yes.
Aren't the facts in that, like the state cited the same case?
Yes.
Aren't the facts in that case important? Meaning the trial court in that case, the state was learning kind of in real time that the court was having a whole side litigation with the defense counsel. It truly was ex parte, meaning no notice, no hearings, no anything. And then the court was entering these side orders that were totally without knowledge of substance or anything related to that case. I find this very distinct and different in this particular case. I've had, now I think this is my third hearing about trying to make a ruling in this case. The Callaway case, you don't find any factual distinction in what's going on here?
I do. The point is well taken. There absolutely are factual distinctions, but the point of that case, and there are others that I can cite to you as well, are that these are two distinct subpoints. So unless the point being from that, and then these other cases that I will cite, is that unless a Category B witness is attempting to be deposed, then certainly the court may and absolutely is expected to review documents in camera. Absolutely. But for there to be the presence of counsel and argumentation to be made, that runs afoul of the principle of not just Callaway, but I can read here you also from Ocala Star Banner versus McGee, 643.
Wait, you're going too fast. 643.
Yes, Southern 2nd, 1196. Quote, Upon request, the court conducted essentially an ex parte hearing and an in-camera examination. We cannot condone this procedure, unquote. That related to some closed records. And then similarly, in Media General Operations Inc. versus State, 933 Southern 2nd 119, the court has held the same thing, that ex parte proceedings were not permitted under Rule 3.22M except to the extent that the defendant is seeking to depose a Category B witness.
Okay. Give me a second to look at those.
Sure.
Southern 2nd 190. I want to make sure I have. Is 643 Southern 2nd 196?
1196.
119. I'm like, this case doesn't even look. All right, 119. I missed a one. Okay. I'm like, whoa, what is this? Give me just a second.
It should be from the 5th DCA.
Yes, sir. I'm sorry. I was like, what in the world is this?
I was speaking quickly. I apologize.
Okay. Three Southern
2nd 1199. There are some factual distinguishments to be made there, but there are the same statements and principles being applied.
Okay.
Beyond the
Okay, I'll hear you.
Thank you, Your Honor. The second issue beyond the procedural problem is.
I'm still stuck at the procedure. I'm interested in, so in the second case where the media took the writ from the trial court's procedure, the way that I'm reading, and I want to allow you to be heard, is it says they were determining whether the trial court violated procedural due process or whether the order departs from its essential requirements, which is the requirement to get the appellate court to stop and review the trial court, its procedure. And it says, in this case, it says the state acknowledges that the trial court may conduct an in-camera review of discovery materials sought to be exempted from public disclosure. To me, this distinction is important. The state, while it has broad rights, what is being concerned in this particular case is the defendant's Sixth Amendment right, which the state does not have. The state sought in-camera review of things that should be publicly disclosed pursuant to a statute, I believe, is what they were trying to submit everything to the court. So the court would, I guess, go through their public records review, which is odd. But then it says the recent decision in Callaway is instructive. In Callaway, the defendant claimed that Rule 3.220M allowed for ex parte in-camera inspection of purported work product materials for the defendant's psychiatric expert. And again, Callaway is also important because it was factually very strange that the court was having this whole side litigation, and it said the court rejected this contention, observing that an in-camera inspection and an ex parte proceeding are not one and the same. And it said, indeed, the ex parte proceeding is proper only when permitted by law. It says, although Callaway trial court correctly concluded that it had the authority to, and in fact did, conduct an in-camera inspection of the underlying materials, that inspection improperly occurred after the defense submitted the materials to the trial court without notice to the state.
Right.
Big and says, although the state was not entitled to review the material submitted for the in-camera inspection, the state as a party was entitled to the notice, that is due process, and the opportunity to be heard, again, due process, and any hearing regarding the alleged privileged nature of the material, again, due process. The state's rights are in due process. The state's rights are in the hearing. The media's rights are in the hearing. The media's rights do not lie in the constitutional confines of the Sixth Amendment, the way that I see it. And it's not saying that the court was improper in excluding. It was improper in the procedural notice. Callaway, to me, turns where the trial court was not allowing the parties due process. Not that what the court did necessarily was inappropriate, because there was no due process notice. So that's what I want you to comment on. Like the procedure, we had that whole hearing. The court was inartful. I believe I corrected when ex parte means total exclusion, total no notice. And like I'm doing my very best to give notice to everyone that is interested. Yes. All right.
Yes, ex parte, and of course, WJX's position is not that you do not have the authority. You absolutely do to look at any materials that are submitted in camera. That is absolutely correct. The point is that whenever it is accompanied by the presence of counsel and argumentation, the public, and this goes to the second point that I'll get to, the public have a right to be there simultaneously with that. So yes, typically, as the Morris case and other cases that I'll cite to in a moment describe, the parties are expected to be artful in their language enough to not divulge whatever is sensitive, to be able to explain, okay, when you look at these documents in camera, here's what you are going to be looking for, this privilege or this sensitive information, and all of that must be done in open court. Then the court then takes those documents, pursuant to that argumentation that was made publicly, back into chambers and can review to his or her heart's content. That's the distinction. Ex parte means when there is a party or party's counsel and the judge in exclusion, in communication, in argumentation to the exclusion of the public and or the other side. So that's the distinction. So certainly, yes, it is expected that you will take whatever documents need to be reviewed and review them in camera. But
you do know the problem with this case, do you?
I am vaguely aware.
Okay, tell me what you're aware of.
Well, see, as was, I'll read, on July 21st, the defendant, and this is from your order from 2 days ago, the defendant moved orally in camera based upon a privileged information to supplement their motion related to the materiality prong of the subpoena ducis tecum. What I think that, I'll try to cut it off to be brief, there's a case from 1988 in the Supreme Court called Morris. And I will go ahead and cite to that. And what the trial court did, it's Barron versus Florida Freedom Newspapers. And in that case, the trial court closed the proceeding based upon what it articulated as cogent reasons and said, if I explain those reasons in open court, then the cat will be out of the bag. I will not be able to, the reasons that I'm trying to protect will be divulged. So I am going to enter an order closing, and I will not explain why based upon the Lewis factors, which we'll get to in a second. And the Supreme Court said, no, you can't do that. You have to, if you're going to exclude, and we'll get to the reasons why in just a second, you have to evidentiarily show all three reasons. You can't say, well, if I state it, the cat will be out of the bag and the whole point will be moot. That violates Lewis, and it violates the First Amendment rights of the public. So that's the issue, is that, yes, there may be issues that if they are publicly articulated may let the cat out of the bag, but still, unless they are adequately explained in an order with findings of fact and conclusions of law that are articulated factually in such a way that interlocutory immediate appeal is possible, then it violates the Lewis standard, which we'll get to in just a second. So that's the problem, is that there must be articulated reasons, both of fact and law, for all three prongs of the Lewis test, which I'll talk about in just a second. So yes, if there are these other issues that let the cat out of the bag, that still doesn't.
No, that's not what I'm asking. I'm asking you, do you know what this particular factual issue is? Which is, this is for subpoena, this is for production of something that does not exist. Then I have a next of kin / for constitutional purposes, victim that is asserting privacy rights, that if you layer on the other case law that's been cited by Mr. Clifton and my review of the Florida Constitution, additionally also related, that I have to, before I can just kind of in whole cloth say, download someone's entire life. Okay, download someone's entire life, and then I'll look at it, which is in my read, not permitted. So I can't just, because it doesn't exist for the court, doesn't exist for the defense, doesn't exist for the state. They say they're not looking, they haven't downloaded. So therefore, using the confines of what I have, which is representation based on deposition, because these cases, in my mind, don't answer this very particular, very unique factual circumstance, in the sense that when the other cases that I look at with download, the court had ordered it, it was there. This court, me, trying not to download Ms. Bridegan's life. You know, I'm trying to make a path so I can make a ruling, and then respecting everyone's rights. So that's what I'm asking. Do you know this particular problem, which is there aren't any papers that exist, there aren't any materials that exist, because I'm trying to craft or determine if at all, these portions of Ms. Bridegan's phone, which the defense asserts as evidence of some sort, should be even delved into and balance her privacy rights.
Yes, and it is WJX's position that any argumentation that is made pursuant to that must be made in open court pursuant to the Lewis standard. That's all that I'm saying.
And there's no Sixth Amendment carve out.
The Lewis test expressly articulate
what's Lewis?
Lewis 19. The Lewis case is Miami Publishing Company versus Lewis, 426 Southern 2nd, Florida, 1982. Florida 2nd 1, Florida 1982, and it specifically contemplates the Sixth Amendment rights of the accused, and specifically it actually arose in the context of a suppression hearing, but it accounts for, as the first DCA has contemplated, any criminal judicial proceeding, whether pretrial, jury selection, trial itself, or anything related to those, any procedure. And you can look at the infamous case that came out of here in Duval County. Are
you talking about the Dunn case?
Yes.
Okay, well, I've read that.
Yes.
I think I cited it.
Yes.
at one point.
Yes, and that affirms Lewis, yes.
Okay.
That essentially, the Lewis test applies whenever there is any attempt by the criminal defendant to close any pretrial trial proceeding whatsoever. And the Lewis test has 3 prongs. And the Lewis test states as follows. Well, first of all, the prefatory statement is that the Supreme Court of the United States says the court has noted repeatedly that a trial is a public event. What transpires in the courtroom is public property, and public access serves as a check. It explains all the rationales why. I will not belabor that point. But then it says, quote, the trial court should begin its consideration with the assumption that any hearing be conducted in open court unless those seeking closure carry their burden to demonstrate a strict and inescapable necessity for closure. Strict and inescapable necessity. To that end, the court must apply the 3-part test that's laid out in Lewis to demonstrate that requires the movement, the criminal defendant, to demonstrate that strict and inescapable necessity. And the first element that the criminal defendant must prove is that, quote, closure of the proceeding is necessary to prevent a serious and imminent threat to the administration of justice, that no alternatives other than a change of venue protect the defendant's fair trial rights, and C, closure would be effective in protecting the right to the accused without being broader than necessary to accomplish this purpose. And the moving party must satisfy each of those elements evidentiarily. Allegations of counsel will not suffice. The court said, quote, those seeking closure have the burden of producing evidence, and by proving a greater weight of evidence as to each of the elements, that closure is necessary. The presumption being that a pretrial hearing should be an open one, close quote. Moreover, if the court permits closure, the judge must make specific findings of fact and conclusions of law as to all 3 of the Lewis prongs for the purposes of expeditious resolution of an interlocutory appeal permitting closure, and that's on page 9 of the Lewis case. And so at this point, we have sort of an unelaborated claims of privilege and non-existent. Right now, has been no evidence that I have seen proffered to satisfy any of the 3 Lewis prongs, much less all of them, to demonstrate that strict and inescapable necessity that the Supreme Court demands. And so really that's WJX's point, is that substantively there has not been that evidentiary proffer that is necessary to permit the court under the First Amendment and under Lewis for closure.
Thank you.
Good morning, Your Honor.
Good morning.
We rest on the arguments made by prior counsel. We would just add, going to the point as to what he said regarding whether or not this is the least restrictive means possible, to the extent there is a avenue in which 90% of the hearing is open and to the media, to the public, and if there are sufficient privilege arguments made in that hearing, which the media is privileged to hear the arguments being made, then this can be moved to another venue sufficient to meet the Lewis test. But we do rest on prior counsel's arguments for judicial efficiencies.
Thank you. Mr. Clifton.
Thank you, Your Honor. I wasn't going to argue this morning.
You just want to rest on this, or you want to talk to me?
I agree with where they went with this in regards to how the hearing can be developed, because I think that does go into my arguments and what I filed with the court.
Okay.
And first, I just want to apologize. We did file an amended. I wrote this.
No, it's okay. It's okay.
I spelled Marcy's Law, which is embarrassing. Anyways, what we're claiming in this, and I think it's just a plain reading of the statute itself, when you look at the Florida Article 116, and it states that the victim has the right to be heard, and it says in any public proceeding, but then gives examples of those public proceedings, but then goes on to state, and any proceeding during which a right to the victim is implicated. So that's 2 separate proceedings there. You got public proceedings and any proceeding during which a right of the victim is implicated. Obviously, Mrs. Bridegan's rights are being implicated in this. It's her cell phone that they want to search. If there is an in-camera hearing, which has been ordered by the court, we're just stating that it should not exclude Mrs. Bridegan. She has a right to be there. She has a right to rebut the arguments that are going to be made, because this isn't just a presentation of evidence. It's not in those similar situations were discussed in other hearings where, say, you have a juvenile come in and present the testimony that he's going to state to the court in camera, or you have documents that you want to show. Now, if during this hearing, and I think that's where counsel from Marks Gray was kind of going, was if during this hearing they say, Your Honor, you know what, we have a statement that we want to just be in camera. then maybe that could take place. Your Honor can review it during the hearing. She can see if that's going to be in camera or not, and you can make that decision on site.
How would I do that?
Because they'll just bring it to you. Or you can ask us to leave. You can ask me to leave the courtroom. And I've done that before in hearings myself and said, Your Honor, I want to say something that my client has told me and I don't want them to know. Please excuse them. But that doesn't mean I get to have a hearing by myself with Your Honor. And that's what they're asking for. They're asking for to come in and present argument. And frankly, Your Honor, they have presented argument motions that has been inaccurate. And if they're going to present argument, they're going to say things to you.
So let's say I do what you're proposing to me, right? How is that different than what I was going to do anyway?
Because we're there. We're there for the actual arguments and presentations that are going to be made.
But they say they say in this moment, our next 3 sentences are going to be sensitive in nature. Then there wouldn't be the same objection if I asked counsel to leave?
If they give a reason for it. I mean, it's not just, this is all secret, Your Honor. It's, Your Honor, you know what? We have a statement or a text message that we found on AB's phone that contradicts something Ms. Gardner's going to say, and we want to show it to you. That's a showing that we are now here and this needs to be in camera and we don't want to present it. But just to say we can't say anything about our defense in front of the victim, that's not their right. The Sixth Amendment is a trial right of confrontation, not a discovery right to compel whatever discovery you want. They can confront her. They confronted her for 9 hours already.
Well, I'm gonna put this to you because you've been in all these hearings, right? The objection to the second deposition, then I overruled that. I allowed the deposition, trying to balance both the interests that I knew through the papers that it was a very extensive deposition, that it lasted for hours. And then it was culled down to whatever areas. And then in this latest pleading that has generated this litigation, in those papers, the defense writes the court saying 3% of these messages were delved into. And so you're saying your proposal, I'm trying to get where your position is. So you're saying, from what I know from the papers, that this hearing takes place. They go forward with whatever evidence that they have, that they believe that they're deserving of Ms. Bridegan's additional information. So then at that point, when they say, we want to assert this very limited, privileged argument related to after that evidence is concerned, you say that would be an appropriate procedure for the court to then just excuse counsel briefly, take that and either go forward or not.
If they are providing a particularized reason for it, then yes, I believe you could say, step out, I want to review this real quickly, and then you can make the decision right then. You know what? This isn't, this will be public. Mrs. Bridegan can hear this, and then you can make that decision then. Because otherwise, what's happening then otherwise is they are just having a separate hearing and they are allowed then to present whatever they want and it's unrebutted, and to take the victim out of that completely, I think is against her constitutional rights. And I understand Your Honor, you're in a difficult, it's a unique situation that I've not been able to find case law.
Me either.
And I understand that we're trying to craft something that works for everybody, but they have a right to confront a witness. They have confronted her. Mrs. Bridegan is...
Well, no. I'm not there yet. I'm not at the confrontation. I'm at the broad liberal discovery rules that, honestly, I'm treading new ground. So we've been deep diving into F. We've been now messing around with subsection M, but also there's B, that no one is even talking about, which is B is the defense has to be given statements, and it doesn't necessarily preclude that it comes from a phone. and then, but I also have read and take to heart the arguments that have been made by counsel, Mr. Clifton, in a very coherent way. And I've read Marcy's law more times than I think I ever have. But also the defense in Marcy's law has a separate implication of what they're requesting too, which is the rights of Ms. Bridegan to have communication with the prosecution. They're asking for that too. But I'm trying to understand, is this a distinction without a difference? So if you all came to what I have scheduled on Monday and I start the hearing publicly and then they say, Judge X, I have a brief excusal, then you all come back, I make my ruling, how would you be able to rebut it?
If they provide a reason, and let me just show you, because they did the case. And they did not. Ruling on it. For the text messages of EF, in their motion they write, EF said this in her deposition. EF said this to our investigator. We believe then, based upon that information, that there was some type of communication between these two where there was influence. And you said, okay. And I mean, we'll get those messages to the court. Your court's going to review those in an in-camera review. I mean, that's the process. For everything else, everything with A, B, and LB, it's just, there must be influence, there must be bias, and therefore we need to see it. Well, that's not it. Do the same thing you did with EF. You know what? We have this message here. We have this testimony over here. AB is saying this, or some other witness has made this statement that's in contradiction, or that at least raises to some level of suspicion. Therefore, we want the opportunity to look further into this, not just to make vague assumption or accusation of bias and influence, which is all they have done. Your Honor, they have said, all these messages exist, and we think that they're biased, and we think that there's some influence in them, so we want to see them. When it came to EF, they were very clear. When it comes to everybody else, nothing. Silence. And
different. In the hearing, Ms. Nelson, I don't have my notes with me, but like my memory serves, and it can be corrected, which I believe that Ms. Nelson said, because I took a break, something to the effect of like about the messages between law enforcement and the prosecution, that they wanted to give me that information separately. And then there was we skipped past it because I had not read the cases at that point in time, and I was hesitant to even do any of that.
Then they have to provide, I mean, there it is. I mean, then give me some type of particularization of why this is even an issue.
Okay.
I mean, that's what we're asking for. So if we're in the middle of a hearing and they say, again, Your Honor, they say, listen, we have a statement from this witness and it contradicts something she said, and we want to be able to show you something that's to our defense strategy without them in the room. Can we please do that so you can decide whether it's public or not?
Okay.
Then we deal with it.
But then, Mr. Clifton, like, I'm still stuck at, like, because I limited based on Ms. Bridegan's objection, and understandably, it was a very particular and long period of time. And then it has also been argued to this court multiple times that they have the other part of the two-way communication without any acknowledgement. I have no clue, but it's been argued several times.
It's been attached to the deposition. I mean, they attached the document to the deposition.
Which one?
The first deposition, Your Honor.
The first depo?
Attachments were under seal, but there is. So, you know, and
Ms. Bridegan's first depo? The second part?
No, the first deposition that she had in.
Oh, you're saying in the depo there's questions related to AB and LB.
Actual document showing a text message, and I believe that was attached to the deposition.
I only got a summary. I got, it's like 4 pages on every page. That's what I got.
Okay, well,
I don't have that. I don't have what you're talking about.
okay.
Okay.
All right, so, I mean, it does exist. And I mean, I don't want to.
Okay, no, I'm, right.
I want to kind of stay focused on just, I understand that, you know, this upcoming hearing, it may not be ideal, but it's the least restrictive, I think was the correct word for it, because otherwise what you're allowing is a separate hearing for the defense to make arguments. And that is our concern. If they can come in and just present what they believe and why without any rebuttal whatsoever, then how do we, I mean, because, you know, frankly, Your Honor, if you say, all right, well, I'm going to order the subpoena and then I want to file a motion to quash, what am I filing it on? My inability to do anything. I don't know what they're arguing. I have no clue what happened. Now, if they have, you know, they're going to have to present something. I'm sorry. Sometimes in law, you got to make decisions. You got to weigh it. Hey, you know what? We want this subpoena. We really want to look at those records. You know what? We're going to have to admit a couple things. We can't just say, we're not saying anything. She can't be here. We want those records. And no one can know why, except for Your Honor. That's, I mean, you got to balance things as a lawyer, and sometimes you got to give up some stuff. That's just the way it is.
Okay.
So, again, just, we have addressed it in our motion here. There really is constitutional rights here. She has a right to be at this hearing. There is a way to figure it out. And just to throw a little something else at Your Honor, I'm not going to be available on Monday. So I put at the end, if by chance Ms. Bridegan is allowed to be at this hearing, if it can take place on Friday, I'm going to be in the mountains and I can't guarantee I have Zoom.
I'm running out of runway, Mr. Clifton.
I do. And it just
I don't have a lot of time.
4-day window to
I got
allow
it
to happen that way, Your Honor.
Okay.
Thank you.
All right. Ms. Nelson.
Thank you, Your Honor. I'll start where Mr. Clifton left off. And the point I want to make perhaps addresses both, I'll say, sections of argument, both from Mr. Clifton and from the attorneys representing the media outlets. I think there's a fundamental misunderstanding about what the defense asked the court to do and what I understood the court to order. And that is that we are giving a proffer. A proffer is not an argument. A proffer is a statement of what we intend to cross-examine on at trial and what touches on themes of our defense. That's not argument, Your Honor. It is a proffer. I think that's important to ground this conversation because much of the points made by both Mr. Clifton and the media are grounded in this idea that we'll be making argument to Your Honor without parties being present or without ability to respond. That's not what we intend to do. We intend to be very narrow and limited, and that's what we understood the court to be ordering. I also want to make clear that the court is in a difficult position of balancing Ms. Bridegan's constitutional rights and Ms. Gardner's constitutional rights. But that's exactly what we're asking the court to do, is a balancing. Neither one is absolute. However, Ms. Gardner's constitutional rights are both guaranteed to her under due process in the Fifth Amendment and the Sixth Amendment. It's not simply just a right to confront witnesses at trial. It is also her fundamental right to effective assistance of counsel. That includes pretrial work, that includes us not revealing our defense strategy and giving a blueprint to cross-examinations of some of the state's key witnesses. I've made this argument before, so I won't belabor the point, Your Honor, but that is both a constitutional right of Ms. Gardner's. It also implicates my ethical obligations.
Well, Ms. Nelson, I guess let me ask you this, okay? The point has been made multiple times. The state, now the media, now Ms. Bridegan's attorney through a filing. Their objections, both procedural in nature. Is there, from the defense perspective, a cleaner path to get to the same point procedurally? This seems to be, the procedure seems to be quite onerous to me, where I want to get to the ruling. I've been trying to get to the ruling for, I think now about a week and a half or maybe two. Is there from the defense perspective, and I put the questions to Mr. Clifton, but really I need to probably put the questions to the defense, which is, in your papers, you allege like there's only 3%, but then there's been argument from the prosecution and also Mr. Clifton now that you have the other side of this two-way communication. So if that is the case, isn't there a cleaner procedural avenue for the court to go through as opposed to this in-camera hearing?
I appreciate the court's question. I think there is a way to thread this needle. So what I would propose, Your Honor, is that we can come back to court on Monday, setting aside Mr. Clifton's scheduling issues. So if we need to move it, obviously the defense's preference is to move forward on Monday. We come to court. It's an open proceeding. We can be prepared to make additional argument that I believe will get us closer and narrow what would need to be done in camera. And then should the court have additional points, should the defense want to make additional proffer to the court regarding defense theory, we could then do that separately, very similarly to what Mr. Clifton was asking for. I think that that would be a way to thread the needle. And if there is objection to that, we could take it up at that point. Our position is that there's only so much we can reveal publicly, and that we are happy to get as close to that line as we possibly can, both protecting my client's constitutional rights and upholding my ethical obligations. And we certainly are not asking this court to tip the scales in balancing the different constitutional rights at issue here. And we believe that that would protect Ms. Gardner's rights, it would be respectful of Ms. Bridegan's rights, and it would certainly uphold the First Amendment rights that the media is speaking to the court about. I do want to make separate argument on that separately, Your Honor, but that is our proposal and how to move forward.
I think also, okay, well, let me just pause there. What's the party's position there? The state would be there. The media would be there. What's y'all's, the offer by Ms. Nelson?
That would be amenable to WJX. I just want to clarify one point, is that calling something a proffer rather than an argument may not be the correct analysis. In Morris, the Dunn case, the first DCA said that the access question cannot be resolved solely on the label that we give something. So what is the difference between a proffer and an argument? The functional analysis is what controls, according to Morris. And so attempts to engage in sophistry potentially by calling something, this is not an argument, it's a proffer. Well, what is the practical distinction between the two? The Morris court demands that the court engage in a functional analysis as to what's actually being provided rather than the label that the parties call it. So that's the only rebuttal that I'll make to that point right there.
Okay. But that's what y'all were asking for, is an open hearing until it cannot be open anymore.
Where there's argument or proffer being made, yes, that is public, but the presentation of documents certainly can be made in chambers under the Lewis test.
Okay. Mr. Clifton, you're not available. So, what about Friday? Can we do this Friday?
Tomorrow?
Yeah. I mean, I don't want to do it next Friday.
I'm available tomorrow.
Ms. Nelson.
Your Honor, may I have a brief moment to consult with the team? I apologize. Thank you, Your Honor.
You can go off. Okay. Mr. Siegel, are you available on Friday?
Thank you, Your Honor. Steve Siegel, Assistant State Attorney.
Wait, I'm just, yes or no? And then she's going to come back. Are you, like, she's off the camera.
Oh, I'm sorry.
Can you look at your calendar? Mr. Siegel.
All right.
Okay. works on my computer. Melanie, while we're off, can you show me how this works on my computer? It will. Okay. I have some testing.
Yeah.
Oh, okay. Okay. Okay, go back on. Ms. Nelson?
Thank you, Your Honor. Thank you for the court's indulgence. I apologize for the delay. I unfortunately am out of the jurisdiction and I have a conflict tomorrow. I was trying to see if I could get coverage in order to get to Jacksonville. I'm not able to do that by tomorrow.
Okay.
Apologize.
Okay. Well, Mr. Clifton, you are what, in spotty coverage area?
I think that's it, Your Honor. I mean, you know, Wi-Fi is available almost anywhere these days, but I can't promise that I'll be able to get a full Zoom and be on. I understand, though, that, you know, those hearings still haven't happened, so I don't know. It's certainly not a situation where I'd like to be, you know, not able to log on or for people losing
signal,
not be able to hear those types of situations.
And you're not available until next Friday?
Next Friday. This is not something I can do.
No, I understand. And I'm assuming, Ms. Nelson, you wanted to be present physically, correct?
Yes, Your Honor. I'm available all next week.
Next Friday it is. All right, I'll enter an order. So I don't have to do some unnecessary writing. What I'm going to do is enter an order rescheduling the hearing that was going to take place. Are you available next Friday, Mr. Siegel?
Thank you, Your Honor. Good morning. Steve Siegel, Assistant State Attorney on behalf of the state. I just wanted a moment of clarification. Has the court asked the state whether or not this purported procedure is acceptable to the state?
Yes, I'm going to ask that first. Thank you for pointing that out.
I'm sorry. The state objects to the proposed proceeding. It is still an ex parte proceeding as contemplated, and the state is, I object to it on behalf of the state of Florida.
That you be present there?
If there is a moment during this hearing where the court...
Well, I will let the objection happen. It's going to be a public hearing. That's my understanding, that we're going to have the hearing on Friday.
I understood from listening to counsel that there would be a point at which, if there is a matter that has been particularized, the court would meet with counsel for the defense so that they might proffer to the court, out of the presence of the state, their further reasoning as to why they want that particular material. I still contemplate that as an ex parte proceeding, which the state has objected to.
Okay. We keep using that word ex parte when everybody is in the room. It is an in-camera review, is my understanding, of materials that they were going to produce, is my understanding. After argument is made publicly with everybody here, that would allow for objection or counterpoint before an in-camera review would either be granted or not granted.
When Your Honor conducts an in-camera review, will counsel for the defendant be present with the court to explain?
No. That's what I'm just scratching this whole thing, okay? Which the point has been made. It would be, I'll go back to my papers. I will try to articulate this the best way I can. I've already granted on EF. I'm trying to get to a point where I could do the in-camera review. That's what I'm trying to do. Either I'm going to grant it or I'm not going to grant it per the rules. And so I'm going to scratch the whole, they're going to come in and make whatever proffer. They can, Ms. Nelson, can you do it on a provide materials and give the argument? Let me ask you that.
If the court is direct, if the court is directed to do it in that manner, we will proceed in that manner.
Yes, I am, because this has become almost, this is almost disruptive in the flow of everything. So
we understand the court's ruling and we will respect it.
I will do a second amended, make myself clear. So it isn't, I'm going to either grant an in-camera review pursuant to the rules or not. They're going to make their argument here in open court. Are you objecting to that?
Your Honor, what I would object to, if the court is going to have an open proceeding and they are to make their arguments and the state is present, I have no problem with that. The only thing that I would ever object to at this juncture, until we know more specificity, is any circumstance under which the defense would be present with the court without the state present to continue to make argument, a proffer, whatever it may be as it relates to that. And it sounds to me like the court is saying that's not going to happen.
Correct. I'm going to correct it, that there have been valid points honestly made on both sides. And I, for the life of me, cannot find anything like this. I mean, literally nothing. It's either what has been answered by the appellate courts has been something way less complicated than this. Generally speaking, the state is the one that's doing this for like informants and things like that. Those things are held in camera, but it's a different portion of the rule. This is new territory, so I'm trying to be respectful of everyone's rights and make sure that we can have a path forward. But at this point in time, it's in my view, I need to do the proper analysis, and the procedure is being disruptive. And so, to the extent that I can take away that disruption as far as the procedure and make the arguments that have been made, I think the arguments that have been made thus far related to EF, different circumstance, easier answer, because there was kind of extrinsic through the affidavit and what also existed within her own deposition that made the answer to that, the ruling of the court, a much easier answer. But what I'm saying is the defense points in their papers that they only got 3% of the answers that were posed to Ms. Bridegan related to the other places where they believe that they are entitled to disclosure. I don't want to order any more depositions or anything like that. I think, that's not necessarily contemplated by the rule, even though it was suggested by the state related to EF. It wasn't asked for. And then, so they're saying we only have a portion of the information. The state is arguing they have the second part of it. And I'm trying to be respectful. And if I am going to do an in-camera review, I do know what cell phones are, do know what forensic downloads look like. I don't want to be in the dark if I do grant it. So as much as it can publicly be articulated for the court, and if I grant the in-camera review from there, if materiality is satisfied, then I would go to any type of particularization if that is the next step. So I'll amend the order today, consistent with the arguments of counsel. Thank you. All right, so next Friday is July 31st. It'll be, are y'all available at 10 a.m.? 10 a.m.
I will make myself available.
No, are you?
Sure I am.
Mr. Clifton, Ms. Nelson.
Yes, Your Honor, thank you.
Thank you. All right, 10 a.m. courtroom 407, right? Thank you all.
All right, so that was a big mishmash of a bunch of stuff. So I don't know what the media was there for, trying to, I guess they just want access to the hearing, but I thought these hearings are just always public. I never heard of every hearing that the media has to go and request to be there, but they basically, the defense is saying they only got 3%. They deposed Kirsten Bridegan, that's Jared's second wife. They only got like 3% of what they felt they should have gotten. So now they want to subpoena her again, subpoena her cell phone, and they want it to be in open court. So Judge Kite is going to allow that, and then she's going to have to determine. And then the state was saying, well, then after that, you're going to have to go into closed court and do an off-camera review. They just didn't want the defense to be there. So that was, and she says, this is very disruptive. And I'm like, every hearing we've watched of substance of more than like a half an hour, it seems disruptive. Like this trial is just so, I don't know if the trial is going to be like this, but you guys remember, I don't know if you remember the first couple hearings that we showed. The state was yapping at the defense. The defense was yapping at the state. They were saying they weren't turning over evidence. They were keeping evidence. They were giving them, like terabytes of, like hundreds of terabytes worth of data, and they couldn't. It was a big mishmash. So I don't know if they've kind of calmed down and have decided to play nice with each other. I don't know. All right, so this was July 27th. So it sounds like there's going to be another hearing tomorrow. She said at 10 o'clock. So we'll cover that. And then Corey Richens has something at like 1:30 their time. So that'd be like 3:30 our time. So we may have a full day here. We may have a full day of court watching. All right, so this is from the 27th. This is an hour, just a little bit over an hour. So now this is about charges. This is about charges in this case. So this one's going to be really interesting. Let's check this one out. Did that all make sense? Did you guys all make sense? Yeah, Missy. So I think she might be for Jose Baez. I think she might be part of his team. I'm not 100% sure, but that was Kirsten Nelson, not to be confused with Kirsten Bridegan. So, all right. Did you guys make sense of my recap there? Oh yes, I'm sure the trial will be at least 10 times worse. That's what I'm thinking too. All right. Arwen, Casey Anthony, Jose Baez used a blame someone else strategy. It was the dad, right? Wasn't he going after the dad? And he was like essaying Casey or something like that, if I remember correctly. Causing lasting collateral damage to several innocent individuals whose lives and reputations were devastated. I'm pretty sure it was the dad, right? If you continue looking that up, from what I remember, I think it was his dad. It was her dad that she said that he assaulted her. He did things to her, if I remember correctly. All right. So this is from July 27th. So this is just a few days ago. All right, let's get to this. So this is about charges. So this one's pretty significant. I mean, all these hearings are significant, but this one in particular is going to be significant. So hopefully it won't be too convoluted. We can actually understand it.
Morning, Your Honor.
Thank you. Good morning.
Christina Stifler and Alan Mizrahi on behalf of the state. We're here on the case of Mario Fernandez, number 1 on the court's calendar.
Good morning, Your Honor.
Good morning.
My name is Jesse Dreiser, and I represent Mario Fernandez. I'm here along with Ms. Day. Mr. Hill had a federal status conference, which he's doing remotely, I believe, in the jury room, and hopefully he'll be out here in a little bit.
Okay. All right, if you would, today is the court's operating final pretrial, and so I may be addressing your client. If Mr. Fernandez, if you would please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you. All right, you can be seated. I'm going to talk to the lawyers for a little while, and I'm going to confirm some things with you, okay? All right, so I appreciate both sides. I've been looking at the diligent work that you all have been doing, even as of late, and so I want to kind of take up one thing at a time, which is first starting with, yes. Okay. Mr. Smith, he said I'm muted.
You're muted at the Zoom.
Okay. All right. And then so I want to take up first one thing at a time. So we are going on the indictment that was initially, it looks like it was filed August 17, 2023. Is that correct?
It is, Your Honor, and this morning the state has filed a statement regarding the indictment. I provided a copy to Mr. Dreiser yesterday, but we've been in discussions regarding this. The state will be proceeding on counts 1 and 3 of the indictment.
Okay.
Which is the homicide and the solicitation. I provided a copy of that statement to Your Honor and have filed with Mr. Hathaway.
So for purposes of the trial, and this is known by the defense, I'm assuming.
It's been talked about for probably 10 days. I got official notice yesterday.
Okay. And so for preparation, instead of filing a superseding document, what I would ask is that the state prepare what we would call kind of a dummy indictment.
Yes.
With renumbering just for record purposes. So 1 and 3 for all of our purposes. So 1 for the official record will remain 1. 3 will become count 2.
You're referring to what you'll read to the
correct
jury? Yes, ma'am, I'll have that done.
All right. And then so I guess the state abandoning 2 and 4?
Yes, Your Honor.
Which is the conspiracy and the child abuse.
Okay. All right. So I believe you can interlineate these documents if you want, and then for just so it looks clean, if you could prepare one for me and one for the defense, but you want to interlineate the document that's filed in the court record.
I can do that. Mr. Hathaway and I will confer, but I don't.
Go through this with him.
I assume this statement regarding the indictment is filed, should sufficiently take care of it.
All right.
It is a joint indictment, so my concern is making any interlineation into Mr. Fernandez's case that does not apply to Ms. Gardner's case. They're on the same indictment.
Okay. So you're going to prepare another document?
Yes, Your Honor.
All right.
And I don't know if she said this, but I do think you would want to know, and I'm sorry if you did, their indictment is not being modified in the same way in which ours is. So.
Right, correct. Right.
But we're going to have a clean document so that I'm not reading.
I agree with that. I just wanted you to know that, that it wasn't the same, meaning.
So what I've done for myself is I've highlighted his name. I was going to only read that portion of it, but it would be nicer for me if I could just read.
Absolutely. I'll make one as if that is the way that Your Honor would read it to the jury at jury selection and trial. I'll provide a copy to Mr. Dreiser for his approval and then forward it to Your Honor.
Okay. And then I did get, I don't know that it's filed though, a statement of facts.
We have agreed on a statement of facts.
It needs to be filed.
Yes, Your Honor.
And.
Right, we can file that today, Your Honor.
Okay. And then, so,
Oh, can I have one moment with the state?
yeah. Hold on.
Practice this. I know, I'm working on it.
Okay, so.
That'll get filed today.
Okay, great. And then in looking at the order that I introduced, that I filed, the way that jury selection is going to go forward, phase one, which is scheduled to start on August 10th, I believe that the clerk's office may be prepared to bring up more than 50. Would you all be interested in that or no? You want just the 50 to work through for the morning? The question was posed to me that, if they had 70, if they had 100. I personally think 100 is too much to try to get through in the morning, especially. I'd rather we can hold over some for the afternoon and get to that point, but I want to have people waiting as little as possible.
No one does this more than you. I defer to you on what you think the timing of that procedure would take. You would know better than I would.
The state's thought process, Your Honor, is that as long as the jurors are comfortable and are not sitting on hard benches in court during this process, or sitting on the floor outside. I've had a case before, too many people. So I want to make sure the jurors are comfortable, they're in a position where they're not being inconvenienced. It doesn't matter to me if it's 50, 60, 70, as long as they're not being inconvenienced.
So this courtroom, I think, can comfortably seat, I think, up to 100. But our magic number for questioning purposes is 100. And so we could possibly, I want to have hard breaks, which will allow everyone to kind of keep the stamina of the trial. So noon lunch to 1 p.m. and if we're more regimented in that factor, but we'll know from the first group. My suggestion would be we keep to the 50, work through the 50. And if we're done a little bit earlier, okay, you can go to lunch earlier. Then we bring another 50 and just be more pragmatic about it than bringing up way too many people and then working over. That would be my preference. That's fine.
And how, that's fine, but how quickly, let's just say that the first 50 comes up and 5 people say they have a hardship for timing and calendaring purposes, and 5 people say they know something about the case and our line into room 2 is only 10, and the rest go, and they start filling out questionnaires, how quickly could we get another 50 people is, I guess, the question I'd want to know.
Well, they would be summoned for the afternoon, but then you would have, if let's say we finish early, then you would have the time to kind of go over the questionnaires a little bit longer.
Sure. All right.
So it would just be, if we finished a little bit earlier, that would give you all more time to work and not be kind of under the pressure of questioning more jurors. But I say we kind of stick to that process until we see that how hard or how easy it will be. And so let's say potentially we get the first 50, we're able to work through those individuals very quickly. You'll have a little bit more time as far as a break. We get the next 50, it's a little bit harder because, it's really juror dependent. But the main thing is that we have the groups in here that it's already designated that you're going to have the group that's going to remain in here and then the group that's going to go into the side room where we discuss the hardships, and we can get through those hopefully very quickly. Are y'all interested in my chart for hardships? Do you want that? Yes, it's something I do. I'm going to keep my own, but I'm happy to share it with the parties.
That's fine. Yeah, please.
Okay, so I developed it, I came up with it last time, and then it just allows notes to be kept, like who stays, who goes. All right, so I'll send that to you all.
And just, my recollection was, once we get 100, we'll bring back 100 that day for actual, traditional voir dire, except once whoever comes back out of that 100 will release X amount of people to only have 70. Is that everyone else's recollection?
No, I think we ended up with, we're going to have 100. 92. What? We're going to have 100. Because once y'all get to the questioning, I mean, you don't have to question the remainder of the panel, but it would be nice if you're exhausting cause challenges, if you're like, there are things that you can't anticipate, to have the jurors instead of trying to summon more. But my thought is Monday morning, 50, Monday afternoon, 50. And then I think that we should be able to get to the 100, definitely, hopefully by Tuesday. That's what I'm thinking. And then Wednesday afternoon is when you start your actual questioning of the jurors. So you all will have all that time to go over the questionnaires and do your work. And then we will start Wednesday afternoon with the actual selection process. And that's just in case. So if it's too hard, then we would still have Wednesday morning, another 50.
Yeah, and I would like the court to know it's probably going to be the defense's request that if it starts in the afternoon and the state goes, unless they are real quick, I don't think I'm going to want to go that afternoon, break mine up, and have a bunch of very tired people late in the day.
I understand.
Okay.
But they'll be fresh. That's the point of not starting in the morning.
I understand. It'll be dependent on our request.
So, I mean, I do still have, my thought for phase one is that I come out, I do my normal introduction of myself, of the staff, of the parties. That would allow for that kind of baseline questioning. Does anyone recognize anyone? I read the indictment, I read the statement of facts, and then I'm going to publish the trial schedule. I'm thinking this whole scenario would take, I'm thinking 20, 25 minutes, okay? And then I'm going to tell them that we're dividing ourselves, they're dividing themselves into two different groups. The group one is going to say that they want to be heard as it relates to they've heard something or they think they know something about this case. Group one will also be considered individuals that want to be heard related to hardships or difficulties with the trial schedule. Group one will also be individuals that believe that they know either myself, any staff, or any of that. I'm not taking any questions in a big group. Group two are those that believe none of those issues apply to them and they don't want to be heard. And therefore, they're going to remain in the courtroom. The questionnaires are going to be distributed to them and they're going to complete the questionnaire. I'm going to tell them and read to them, what they are essentially swearing under oath that they're doing, because then they need to know the seriousness of it because before I leave. And then once we divide out into two groups, I've already gotten with court administration that they're going to have sufficient number of bailiffs to help facilitate the line where whoever wants to be in during the questioning will be excusing ourselves. The remainder, we will not be in session in here, but for collection of questionnaires after both sides agree that it is filled out properly, the clerk's office is going to scan and then send those out to the parties. And so depending on those numbers, we'll know how many to kind of, that our cutoff is. And then I was going to give them the report date of Wednesday afternoon, but if y'all want to start in the morning, I'm happy to do that. If we think that, we can always summon more jurors to get to the Wednesday morning. Would y'all rather have Wednesday morning report back date? Because I haven't set that. for the jurors that have finished the questionnaire?
I think that we should start with a Wednesday report back day. But if we notice from the first 50 that we're seeing a lot of hardships and/or media attention,
Just be able to contact those individuals and move it?
we say it's tentatively Wednesday morning, but then, if we see that in the morning and the afternoon that it's going slower than we anticipated, then we can always bump it back to Wednesday afternoon. So I would tell the jury to make sure that we have a good phone number and that they check it and those kind of things. Or they call in. I don't know, they could do a voice recording like they do for jury selection where you call in and it says, you have to show up at Wednesday morning.
I don't know. From the clerk's office, do you know if that's available?
Your Honor, I know that they can update their message, but it's not standard Monday jury selection. That's for the specific animal.
I think my preference is to stay with what your initial thought was, which is Wednesday afternoon. That'll give us the sufficient time that we need to go through the questionnaires and do the work that we need to do outside of the courthouse.
Up to y'all. It doesn't matter to me.
We are in disagreement. I think that we should use the time. I don't want to rush things. I think the court's thing is great. I think that we should be able in 2 days to have 100 people. And I just can't imagine that we're going to have, I guess if we're doing 50 at a time, that's 100. That's out of 200 people that we're going to have 10 people be strict. Maybe I'm wrong.
And I agree with Al.
Even some of the people that have heard of the case are going to be able to sit.
Right.
And this isn't a situation where obviously maybe in some pieces of evidence they are and they cannot sit. But if they're like, yeah, I heard something about a guy shot in Jack's speech, it's not having any, fixed or definite opinions. I think those people are allowed to sit. So I think that on Monday, and if we go slow, perhaps leading into Tuesday, we should have the 100 so come back Wednesday afternoon. I'm not sure but maybe I'm optimistic.
It's not his optimism that is objectionable to me. It's that I'm anticipating the work that we're going to do getting to the 100 and then the work that we need to do to sufficiently understand who these people are. That's the extra time that I'm seeking.
I'll do the Wednesday afternoon. You all can use the time to work on your trial, or we can even use the morning if you need. And let's say you've done your work, that if there are any hearings or anything at the last minute, we can come together prior to jury selection.
Yes, ma'am.
Actually, they'll allow us to finish Thursday.
100%.
Yeah.
And then you would have all of Friday.
Friday for me.
And yeah, my jury selection is not taking an entire day. So
okay.
I don't believe so. And I don't know why. I'm not trying to push back. It's not that big a deal, but I really thought that we had, when Mr. Mizrahi and I were doing the math with the court, we really were comfortable with 70, and then if you want to do 70, it's fine with me. But I said, which I thought was really smart that I didn't think of, was yes, but when we get 70, there's a chance that when the 70 return, you'll get some illness, you'll get some, I saw the case on the news, you'll get some problems. So I thought you were saying, let's get 100. Let's get 100 to return, see who returns, right? And then that'll make sure that we actually have 70 sitting panel of actually 70 by bringing 100, and then we'll excuse the remaining 13 people or whatever.
So how about we leave it the way it is, 100? Okay. But however, you all will know from the questionnaires whether there could be an issue and we can keep the 100 or not. You don't know. There's a great unknown about what people are going to put on their questionnaires. I think that was part of the conversation as well. So we get to the 100. Everyone reports back. You all have done your work as far as the questionnaires are concerned. If there is concern that a number of these people may not be able to serve, I do want to get to at least a good solid 70, and maybe the 70 comes out of the 100, and we can say from the questionnaires, these are problems. We can also bring in people individually that may indicate issue on the questionnaire that is not right for the entire group. So I'm fine if y'all want to just question 70, but we're going to bring back the 100. So if you want to seat 70, is that agreeable with the state?
We can just,
Okay.
we can make that decision that morning.
And then we'll see who comes back out of the 100.
Yeah, that makes more
Right,
sense.
and then after y'all have, because there's a great unknown, so.
You have 30 come back and say, I can't do it.
Correct.
70.
I definitely agree with the 100. We can come to a decision that morning. I think that makes more sense.
So, I mean, you all know,
Thank you.
you all know that in jury selection, generally what happens is they go outside and they start talking to the bailiffs, and they start telling the bailiffs this, or they tell the bailiffs that, and then here we go, losing people. So, I mean, maybe you don't need everyone, so we'll just get to the 100 and we can excuse from there. That's fine. But we'll seat 70. So 30 people will.
When we say that, we go up. We will 70 jurors, 5 on each row.
Does that make sense to the clerk's office?
Yes, Your Honor.
So we're going to bring back 100, but we're going to seat 70 questioning jurors. Okay.
We have a few more. Be on standby, just be listening and parties can agree on the question.
That's what I was, but,
They could be there in case of someone.
All things we can address that morning. Let's see how it goes.
all right, we'll see how it goes.
Does the court know, or maybe this is a better question for the clerk, my understanding is there's 250 like separate summonses going out into the community.
There's way more than that.
Or
to get to the 250.
Whatever that number is. How do we know, what's different about the ones that are going for our case versus different from another case?
So the way that it works is that the general summons goes out. They are all called down for qualification. They have to still go through the qualification process. And then from the qualifications, if they are not excused through qualifications, meaning they don't meet the statutory requirements, then at that point in time is when they're randomly selected and put into a list to come up.
Understood. That's when it happens. It's not on the summons. Okay.
No. I said that I was going to go down, but I've talked to some other judges that are going to cover me, so I don't have that extra duty. But there are other judges that are going to assist me in qualifying, so I don't have to be downstairs qualifying. But once they get through the qualification process, they're then randomly brought up. Like, so there's a random juror list that's generated at that point in time, and that's how we get the 50. So that's what I was saying. The clerk's office believes that they can bring up more than 50 out of that random selection, but they're summoning morning and afternoon, and they're randomly selecting out of that group that is qualified.
My suggestion is, we can see how the morning goes. If 50 takes till noon, then we know 50 is the right number. If 50 takes us till 10:30, then maybe we could bring up 70 in the afternoon.
Okay. And that's all depending, like we have a minimum number that we need, and we can always go above. So I agree with that strategy. Is there anything that you want me to add or subtract from phase 1 about what I intend to do? The introduction of the case is what all I'm going to be doing.
And I'm not requesting this, but perhaps we could include the witness list. Since we're introducing everybody, I don't know if that's necessary. I'm just going to out there since we're talking about all the lawyers and Your Honor and all the staff, but maybe just also throw in the witness list to see that.
Okay, I can do that.
Ms. Rodney, they're not able to hear you on Zoom.
And when we go back into the room for the hardships, Your Honor, you're going to control that questioning and then say, do the parties have any further questioning?
Yes.
Thank you, William.
All right, so if you all, I'm not asking that you file the witness list, but if you could communicate it to my office, and I will incorporate it in the opening remarks. Is there anything else in addition to the case introduction? So I'm really just putting this out there because I did it by order, that for the media, it is my contemplation that part of it will be open to everyone and part of it will not be. So if there is, I'm bringing this to the media's attention that I don't necessarily intend to have the media back there with people talking about their hardships, financial or otherwise. But if you all want to intervene, you need to do it by motion. I'm not going to set a separate notice hearing because I've done that in the prior trial order. So from the defense perspective, the state wants the witness list. I'd like to make sure that you share it because there are witnesses that may not be common to both sides.
Yes, Your Honor. I'm also going to put names that they will hear during the course of the trial, even if they're not witnesses. I think that's prudent given the number of witnesses in the case.
All right, just so communicate, review it.
Dreister and I will coordinate that, and it will include both sides' entirety of names that need to be explored with the jurors potentially.
All right, I'm on to phase 2 now, which, do you all want me to reread the indictment or no? I don't think that I need to, but I'm asking because there will be days in between.
I don't think you need to.
Does the defense agree?
Yes.
All right. And then, so my phase 2, the only portion that I would intend to cover at that point in time is I'm breaking it up significantly from what I normally do. My phase 2 would look like this, which is you were read the information, the indictment on whatever day prior. Okay, then I would go into the procedural history that Mr. Fernandez has entered a plea of not guilty and what this means. And then I go through the state has to prove the charges beyond a reasonable doubt. It is now not required, but basically preferential that the trial court read the entire reasonable doubt instruction. Is there any objection to that?
The new reasonable doubt instruction?
Yes, the new one.
No, I was just emphasizing that. No objection.
I was hot off the press. I think I was one of the ones.
You told us about
it. So, yeah. Any problem with me doing that?
No, we usually request it.
Okay, the entire reasonable doubt instruction. Is there any other instruction that you want me to give? I generally will tell them that, what my role is, what their potential role is, which is the judges of fact, and that our roles do not overlap with one another, that the attorneys are going to talk to you all and question about, basically I explain that you all are not able to pre-try the case. I give a silly example, generally speaking, that explains what they have done, what you all have done with their questionnaires and formulating some questions. And when I say silly example, it doesn't make any sense that I say lawyers are not allowed to pre-try the case, ladies and gentlemen. And so what they have done is they have taken the information. They know all about this case, but they're not allowed to discuss it with you at this point in time. However, they are going to pose questions to you. They're going to require you potentially to weigh your background experiences, things that you have walked into this courtroom with to determine if you can be a fair and impartial juror. And then I use myself as an example, and I say if I'm juror A or juror B, depending on my thoughts and feelings, my experiences, I may not be able to be fair. And I should express that. Or I can be fair, because the experiences I can compartmentalize and base it on the facts and the evidence. But I generally do that. Is there any problem with that?
Not from the state, and I don't think that beyond the reasonable doubt, I don't think there's any need for instructions. I think the lawyers can handle it from there.
Okay. Do you agree?
Yes, ma'am.
Okay. So the role of jurors, the procedural posture of the case, and then I will let you all question from there. So I would anticipate my portion, phase 2, to be about 10 minutes long, and then you all would have the majority of the time.
Yes, Your Honor.
Okay. I just generally forecast that for the jurors because a lot of times they get aggravated or they start asking the lawyers questions like, tell me this, I don't know, and all that stuff. And so I think that has a lot of frustration. The only other one, I can have them reaffirm or re-instruct them on the no communication if you want me to.
I think that's intelligent. And it's also intelligent to remind them that they're still on the road.
Okay. I'm going to have them sworn in again.
Yeah, so I think that, yeah, staying away from the media and disregarding it is always, I'm sure we'll hear that. You'll probably tell them, you're hearing this 100 times. So
I'm going to remind them of what they've signed, and I can, it's more brief, but I can do that. So the communication rules. All right. Anything else that y'all can think of? Did you all look at the questionnaire?
I did.
Yes.
It looked fun.
The revamped version?
I saw the revamped version.
Was there any addition or deletion that y'all wanted to talk to me about?
The only one that I suggested, which I'm sure the court saw and disregarded, was the other significant employment. I always think that that's interesting.
I didn't disregard it.
I can ask it. It doesn't, it doesn't. There's a lot of questions from the questionnaire that we're going to have to go into more detail on anyway.
I agree.
I don't think it's that, it's not necessary.
I
didn't see this. Did you add the handles, the media handles? Yes.
So I put it,
Okay. Number 2, I think.
number 3. So it's name, date of birth, social media names and platforms. And then I revamped the residence area, years of residence. The employment, I can add it there if you want, but like.
It's fine, Ron.
I think how long may prompt you to say, have you done something more?
No, I'll ask it anyway, Your Honor. It's fine.
Okay. I did add prior military law enforcement experience, prior legal education, I should put legal experience. Education or experience, legal education, or I'll put legal experience just to be clear. So this will be duplicated. This is what's going to be required that you all check prior to both sides indicating before they're collected by the clerk and scanned in and sent out to the parties.
You mean check it to make sure all the questions were answered?
Yes, and that there's nothing in addition that needs to be accomplished before we send them away.
Hypothetically, if a question, if an answer is illegible, or we is
yes.
the bailiff going to ask that question? Who will ask that question in the juror?
So I don't have any problem. I didn't necessarily think there was any issue that, I don't know if you want the bailiffs to do it. What's y'all's preference?
I'll do it for them. It doesn't matter to me. I'm happy to have the bailiffs do it.
So the question is, if something is illegible, or if it's not filled out correctly, I mean, do you want
I thought you had instructed us that we should have one of our own team members go through every single one
Yeah.
to make sure that we're satisfied with it.
So what if it's not, there's an issue with it?
Yeah, I assume that you wouldn't want our person individually speaking
No.
to the jurors. So yeah.
But you both, or you could write the note and the bailiff a note could be written saying section 13.
Sure. And then a bailiff would just say, can you make this more legible, or you forgot this one subsection? Sure. Yeah, I have no problem with the bailiffs interacting with the jurors.
Okay, so we'll have the bailiff do it.
And then we had emailed on the questionnaire about if someone had worked in any of the offices, state attorney's offices or any defense offices. Put that in there. Yeah, I'm sorry, I just didn't print the new one, sorry.
No, it's okay. So this is, I did a slight compromise. I made that suggestion
saw the legal experience box.
I thought that would be more general. So that prior military law enforcement experience, prior legal education or legal experience. You don't think that would bring up SAO?
Thinking out loud, maybe dumbing it down to be, instead of experience, working in any law office or something. But that's fine. It's not, I'm overthinking it. It's fine.
Any prior, so what do you wanted to say?
It's fine as a written, Judge.
So it says any prior legal education or legal experience. And I thought that might even capture people that interned or instead of saying working.
We have people that went to law school that never practiced.
I thought it would cast a wider net than, but again, you all can follow up on any of that. So.
Yeah,
do you have a close friend or relative in law enforcement? Do you have a friend so you want someone, you wanted to say?
In box 10, any prior legal education or experience, maybe you or spouse? Any?
If we say spouse, we should just say close friend or relative, because it could be a child or a parent or a sibling.
I just think the more information we have on things that we always want to know, it'll just make your selection go faster.
And that's fine, we can add.
So I have 15. Do you have a close friend or relative who is, I can make that a list. Law enforcement officer, what else?
Attorney.
Okay.
Victim advocate.
I think keeping it generic is better. I think just mirroring that language. Do you or a close friend or relative have legal experience or legal education? The way that Your Honor's written it, just adding in close friend or relative.
So I'm in 15. I'm in box 15. Do you have a close friend or relative who, and I could put a list if you want, and it says yes or no, and if yes, explain.
And what I think Ms. Stifler was saying, and I mean, I disagree, is we leave 15 alone.
Right.
But we compromise by going back to box 10 and adding
close friend or relative.
Close friend or relative.
I don't want to do that because I'll add a box under spouse, okay? Because like that's coming where they are. Like all that information is related to them and their employment. I can add a box if you want that under the spouse, it says relationship status, and then it would naturally flow from there. I'm on 11 and 12 where there's a big heading that says relationship status. I can add another box there that says occupation of spouse, and then I could add one there that says law enforcement, close, but then I think I'm duplicating 15.
I would be okay with the compromise of just adding spouse's occupation in box 12 and leaving 15 the same. Then you'll hit it from.
That's what I have, 12. Occupation of spouse, employer.
Presumably that will answer the question if they're employed in law enforcement.
Or if they're
Right.
at an attorney's office. That's fine.
I'm going to put spouse or a significant other. I'm trying to capture everyone. Do you want to know law enforcement there or just leave it with 15?
Leave it with 15 is fine.
I'm in agreement with that.
All right. And then the children are covered in 14. Age, sex, occupation. Victim of crime, arrested or accused of a crime. I think I might have you. Okay, 17 is you, the juror personally. 18 is friend or family member accused or arrested of a crime. I think that one was a little bit more significantly different than the one I added some. All right, so anything else related to a questionnaire?
Not from the state, Your Honor.
Not from the defense, Your Honor.
All right, and then I intend to work on a proposed draft of jury instructions. I will get that out to you all. I did see that the defense filed an alibi, which I will include. Is there anything else kind of?
We provided all copy of your instructions to defense.
Oh, you did?
Review.
Yes, Your
We
Honor.
can supply that to Your Honor and work off of.
Okay.
We did not include alibi.
I'll forward that.
You do not?
I didn't know you'd follow the notice of intent to commit.
Okay. You know I do the jury instructions, but if you would send them.
I'll send them to court and counsel right now, and then Mr. Dreiser can send the alibi instruction, and Your Honor can at least have those to work off of for the time being.
Okay. Anything else that you all, any negotiations that you all want to place on the record?
Your Honor, there's never been a state offer in this case. There has been one defense offer that was rejected by the state.
Okay.
The defense filed a request to take judicial notice. I think there'll be an agreement on that. I just need to provide some information to the state attorney's office.
Okay.
And we filed a motion to eliminate, state filed a motion to eliminate. If you would give us some time on Friday, that would be preferable. We can knock those out.
This Friday?
Yes, Your Honor.
Okay.
I know you have a hearing in Ms. Gardner's case at 10. We could have time after that, maybe at 11 or 1. We have the afternoon. 1 o'clock?
I have a 1 o'clock now from sentencing. I can give y'all 11.
That's fine with the state.
11.
Yes, ma'am.
So, is there anything else that we need to cover? I'm going to talk to your client briefly.
We have some stipulations we'll be filing between the parties. One was regarding BB's testimony, which I've provided to the defense that we are not calling her as a witness, and a video is going to be stipulated to be admissible. Zoom testimony stipulations, these are things we've previously discussed in front of the court, just officially filing those. A statement of victim identity, I believe the defense will most likely be in agreement with that. And then the defense has filed a motion requesting specific discovery, which I am in the process of fulfilling. And if we don't have satisfaction on that, we can address it with the court Friday during the motions in limine.
Okay.
I say that because our motion asked to be calendared, but I believe we can most likely fulfill what they're asking for short of a hearing.
Okay. I'll cover the stipulations a little bit later. Have you had an opportunity to talk to Mr. Fernandez about it? I can do it real time with the actual stipulation if you want.
Right. For
You want an answer?
For the Zoom testimony, if they're not in agreement, obviously we have to make alternative arrangements.
So he's just signing these I guess these agreements. So they're dropping the conspiracy and the child because apparently
I'm forwarding the jury instructions that the state has prepared to your judicial assistant and CCing defense counsel.
Thank you.
And Ms. Judah with our office, who is very motivated, has been listening, and she prepared a dummy information I sent to defense. And if they approve of it, I'll forward it along as well.
Great, thank you.
Your Honor, at this time, the state would file stipulation by parties for remote testimony for listed witnesses: Taylor Curtis, Abigail Bridegan, George Cruz, and Victor Quiroz.
Thank you. Okay. All right, Mr. Fernandez, you have been present throughout the final pretrial. And so I've got just some questions that I want to make sure that it hasn't passed you by. Okay, this is a very important court date for you in the sense that this is almost the last court date that I'm going to see you prior to your trial starting. Okay. And so first, I'm going to start off with, did you understand that the state of Florida is going to abandon 2 of the counts that they initially filed against you?
Yes, Your Honor.
So now you will be facing trial pursuant to the indictment that was filed for count 1, which is murder in the first degree. That is a capital offense, even though the state of Florida has abandoned or withdrawn their notice of death penalty. There are only 2, if the jury finds you guilty of that crime. There's one punishment at this point, which is mandatory life in prison. Do you understand that?
Yes, Your Honor.
All right. And then they have abandoned count 2, but are proceeding on count 3, which will be renumbered. You, for the remainder of this proceedings, will be for solicitation to commit a capital felony. You understand that?
Yes, Your Honor.
So a solicitation is almost like an attempt. So it takes it down 1 degree, 1 level from what they would call a quote-unquote target offense. Do you understand that?
Yes, Your Honor.
So it takes it down from the capital to the first-degree felony. Am I right on that? No, life. It's a life offense.
Yes, Your Honor.
All right. So I'm looking at the MCL number. So it takes it down from the capital offense to a life offense.
Yeah.
Punishable by life, yes. You understand?
Yes, Your Honor.
All right. So it's important.
I think it's a first-degree felony.
On the MCL, it says 3. It's a first degree. It's 1. Okay. What is the life offense?
What I thought it was.
Are you looking at the MCL? One moment. No, you're right. First degree felony.
Yes, Your Honor.
All right.
30 years.
Up to 30 years, level 9 on the.
Okay. All right. So first degree felony. So to summarize, count 1, capital offense. Okay. Count 2 now, formerly 3, is a first degree felony, punished by up to 30 years. You understand that?
Yes, Your Honor.
Okay. So it's important that you understand what the state of Florida has charged you with, okay? But by exercising your right to a trial, not entering a plea, what you are doing is you're preserving your not guilty plea. Do you understand that? And you are presumed innocent of these charges, no matter how weighty they are, okay? No matter how many years that they could potentially get because they haven't proven anything in court. Do you understand that?
Yes, Your Honor.
All right, so pre-trial, this case has been going on for some period of time, all right? And it's important for record purposes, and not that you have to, nor are you required to, but if there was any negotiations, that will never come in during the course of a trial, because you have preserved your presumption of innocence by exercising your right. But the state of Florida indicated that there was one offer made. Okay, is that true? To resolve the case. Did the defense make an offer or not?
I would not consider it, it was not formal, it wasn't in writing, it was more of a discussion, and we certainly do not want to discuss it in open court.
All right. Well, from the state's perspective, they thought that there may be some avenue for resolving this case short of trial. Let me put it like that. Okay. And they've rejected whatever the discussion was, that they are not interested in it. Okay. Is that pretty much your understanding?
Yes, Your Honor.
All right. Now, I've been talking to the lawyers about how this trial will be progressing, kind of giving a preview of what the jury selection would look like. It's going to be conducted due to some of the interest in the case in 2 different phases, so that we can get to a good questioning panel. Okay, that's where your lawyers are going to be asking the substantive questions of the case, but we're going to handle phase 1, which is hardships and people that think that they may know something about this case. Did you understand that procedure?
Yes, Your Honor.
Okay, and so also, by the time that we get to the trial, your lawyers obviously have been working on this case, investigating this case, representing you throughout this entire process. And once the trial starts, there have been stipulations, which are agreements by lawyers. And I want to make sure you've signed this here in open court. I'm going to go over each one that refers to a witness, Taylor Curtis. Is it Jorge or is it George? George Cruz, Abigail Bridegan, and Victor, is it Quiros? What is it? Quiros. You have certain constitutional rights that this implicates, which is the right to confront witnesses, okay? The way in which confrontation occurs, generally speaking, is in open court, all right? But by the invention of Zoom and the invention of remote technology, it can be utilized during the course of a trial. Have you gone over that with your attorneys?
Yes, Your Honor.
All right, and I am going to tell you that I'm familiar with the law that is required, that is that you, even if you have agreed to this, which I'm going to get to in just a moment, if this goes forward, this is going to be the procedure. I'm going to tell you because it's required by law, okay? Number 1 is that you can see the witness, okay, very clearly. 2, the fact finder, the jury, can see the witness, okay? Number 3, the witness can see you. All right? And so those 3 parameters at a bare minimum have to be satisfied. So it's as if they are in a courtroom of law. And then what also must be impressed upon, so I will allow this procedure, but it also needs to be impressed upon the witness. The other component of that is that the witness is in a location that impresses upon them that they are in court, that the seriousness of their testimony is impressed upon them, that when they take the oath, that they know that they are swearing by penalty of perjury to give appropriate testimony, just like any other witness. So they need to be in a setting that is stationary, stabilized, not noisy, those types of things. So the witness knows, okay, with everyone seeing, okay, that they know the seriousness for which they are testifying. You understand that?
Yes, Your Honor.
Okay, so I'm sure your lawyers have gone over that with you, haven't they?
Yes, Your Honor.
All right, and have you, and I've seen you sign this in open court, have you had time to consider that?
Yes, Your Honor.
Would you be in agreement with that procedure?
Yes, Your Honor.
Okay. Did anyone threaten you or coerce you to stipulate, along with your lawyers, to this procedure? All right, I'll accept each one of the stipulations as freely and voluntarily entered. There are other stipulations that may come up, but these are the ones I'm going to cover today because it requires planning purposes. All right. Is there anything else from the defense perspective that you want me to discuss with Mr. Fernandez? I think that was it for me.
No, ma'am.
Okay. So just so that you know, this jury selection, we're hopeful that we can be done with it in short order. But I think that you have not been present. The times that we're not necessarily working with the jurors will be time that your lawyers will be working with you, okay? And throughout that process. And just for trial scheduling purposes for the lawyers, I'm going to try the best I can that we are working normal working hours, okay? And I think it helps everyone with the length of this trial and the amount of information that they're going to have to kind of deal with. I'm going to give like full notepads to them. Is there any objection to that?
No, Your Honor.
I'm going to allow them to take notes. I think I shared my preliminary instructions with you. Was there any objection to those? I can resend them if I need to.
I'm sorry, say that again, Your Honor.
The preliminary instructions. I think I explained, I take the standards, but I reorganize them to the way that.
That's fine.
No objection. No.
Okay, was there any objection to the preliminary instructions that I give? It includes notes. It is discretionary whether jurors can ask questions. I was not going to give them that option. Unless y'all want to be heard about that. Jurors questioning witnesses.
No, Your Honor. No objection to not allowing that instruction.
Okay. So it would just be the preliminary instructions and then the notes instruction, and then it would be given out opening statement.
One moment, Your Honor.
Okay. Do you want me to resend the preliminary instructions? It's different than the standard. No.
I don't. That's fine. Thank you, Judge.
I have just a last order of business too. Okay. Did you want to be heard about the questions? Because I wasn't going to let them ask.
No, we do not want to be heard.
I'm sorry?
We do not wish to be heard on that.
Okay, so you're fine with no questions by the jurors?
Yes, Your Honor.
Okay. The last thing that I was going to cover is, was there thought, I've got to file some administrative orders for the clerk's office because there will be interest in this case, and have y'all thought through, I'm going to file the order to keep the names of the jurors confidential. I think I've discussed that with you. Is that also still the party's request instead of sequestering?
Sure.
Yes?
Yes, Your Honor.
Okay. Then the clerk's office, you all have gotten with them, right, about potential pre-marking exhibits?
I spoke to Mr. Hathaway this morning. I know that the clerk's office has been in touch with both parties. We have conducted an evidence view and exchanged evidence lists. So we have a multitude of exhibits we've agreed are going to come in by stipulation, so the clerk's office can pre-mark them.
The last thing I'm going to put as far as evidence is concerned on the party's agenda is that I don't know the nature of your evidence or what it's going to take up in the courtroom, but I would request that if you need additional tables that you get with or places to store, that you all get with the court administration and make sure that those that is available to the parties. The next thing is that there will be requests, and I want to allow for organization purposes. I've got to put in an order related to how the evidence will be communicated once it is admitted into evidence. There will be requests for the clerk's office. Correct me if I'm wrong. I think that's what we discussed, that generally speaking, there's a request to the clerk's office to make the exhibits available.
For the jurors?
No, to the public.
Media.
Have you all thought through that?
Not really.
No, Your Honor. I mean,
I need you to.
Other than we discussed the publication of sensitive photographs during the live stream, but
I need y'all to do that because what's going to occur is sometimes, like when y'all stipulate, they become the clerk's office and they become public record potentially. So I need you all to make filings about how you want, because I don't know what your evidence is. And so for me to administratively control that and not have to deal with it during the course of the trial, I need you all to research that and figure out what your positions are and file your papers so I can do that.
yes, Your Honor.
Yes, ma'am.
Okay. So you may want to look at some of the cases that were tried that were high publicity cases for the motions that were filed, but my understanding, once you stipulate, once they become clerk to the clerk gets requests to disseminate those things. Okay.
I'll discuss with Mr. Dreiser and Mr. Hill.
All right. So if we can address that, I'll table that for right now.
Yes, Your Honor.
But the jurors, I'm going to go ahead and enter that order because we're not going to sequester until they start deliberating, correct? Is that still the thought?
Yes, Your Honor.
Yes.
Yes, okay. Okay, I think that was it. You wanted to cover something.
We have access to the courthouse on the weekends because we come in for J1 regularly. I don't know that we have access to a courtroom the weekend prior to either a jury selection or more likely maybe the following weekend. I would envision it would be helpful if we could come and drop off a bunch of boxes and folders and things like that. So the day of, we're not like schlepping, baker's boxes in here. So I don't know if there's a way we could contact somebody at security who could maybe buzz us in for our closet or something like that.
Don't you have a conference room?
In the courthouse?
Yes. I think Ms. Janako is giving you all a conference room.
I didn't know if it was going to be just that.
No, that's a jury room.
But they're going to be deliberating on that side, so I didn't know if that was going to be our conference room.
No.
Okay. But then, yeah, if we can have access to that.
So you, just, if you would contact Ms. Janako and she can make arrangements to have you all in here the weekend prior, whenever you want to. You just make an appointment.
Great, thank you.
And then she can coordinate with the bailiffs. And my understanding, I'm not exactly sure where your conference rooms are, but you're going to have conference rooms available to you. So you're not in the courthouse or in the courtroom. You can have someplace private and you can store your boxes there, or I think that would probably be more secure than
Right. Thank you.
in the courtroom. But I'll let you get, if I need to be involved, let me know.
I can email.
Is there anything else from the state's perspective?
I don't believe so. Can I have one moment, though?
Looking to see if they have anything additional. Did you have an idea of what your daily schedule is? You said you were basically full work. Did you know what that looks like on the start time?
All right, I'll be available to the parties at 8:30, but we would start if the parties anticipate any issues, I can always come earlier. But I want to start with actual court proceedings, 9 to 12, and then pick up in the afternoon, 1 to 5. And so the jurors would have a 9 to 5 day, every day. But I'm available starting in August. I generally get to the courthouse anywhere between 7:30 and 7:45 every day. So if y'all needed me earlier, you can always get me.
Great. All right, well, thank you very much. If we don't have anything further, we'll see you Friday.
Is it Stifler? Did you? Okay. All right, thank you all very much. Court's in recess.
No, this is great. I love this behind the scenes. Now we know the schedule is going to be 9 to 12. Oh, is he still talking? No. 9 to 12. They break for lunch. 1 to 5. I love all this behind the scenes look. because we rarely see it. We rarely see it. All right, so they want to seat up to 50. They're going to, more than 250 summons went out. And they're going to seat 70. They want to seat 70 jurors, prospective jurors. So let's see, they dropped 2 of the charges 2 and charge 4. She didn't talk about charge 4, but that was the child, because there was his daughter was in the back seat, and apparently she was very, very close to getting hit. So what happens is he's driving home, and there's a wheel tire in the middle of the. It's not a road. I think it was. Next time we do it. Well, I guess we're gonna be showing tomorrow. So I'm gonna do a Google map tomorrow, and we'll show you exactly where this is. If I remember correctly, it's kind of like a dirt. I don't know if it's a dirt road, but it's not a main road. It's like I kind of remember like trees kind of growing and stuff. So anyway, he stops. Jared stops, and here, let me put this over here. Jared stops to get the tire out of the road, and he gets shot. And apparently, his daughter, who's in the back seat, was very close to getting hit. So I got to update that because Mario just turned 38. He was born in April. I have to update that. He's born April 4th. So let me update that. I'll update it. I mean, not now, but let me just get all my notes sorted out. April 4th, 1988. All right. Mario Fernandez Saldana. All right. And apparently there's going to be a hearing tomorrow. So we'll go ahead and we'll do this hearing tomorrow. And then also there is Corey Richins. Corey Richins is on tap tomorrow for her reimbursement, and I think that starts at 1. I think it's like 1. I'll double check. It's like 1 or 1:30. So that would be like 3:30 our time. So yeah, all right, you guys. Hey, as always, Grampy, if you're watching, here's your girls' Super Bowl. It's hot. It's very hot here. Everybody's hot. We do have the AC going upstairs in the bedroom. So if she wants to, she could go upstairs, but this is how hot it is right now. It's hot. I'm hot, and not in a good way. All right, you guys, appreciate you spending your day with us. I think I'm in the midst of a fever dream right now. Thank you for spending your day with us. Really appreciate it. Thank you for watching the Colin Gray sentencing and then jumping on over here with us for Shanna Gardner and Mario Fernandez. Mario goes first, and then Shanna goes after that. So really do appreciate you spending your afternoon with us. And thank you to our mods. Thank you to Aaron. Join us tomorrow. I think it's either at 10 or 11. It's either at 10 or 11. We'll do another Shanna one. Actually, it's going to be Mario because he's up first. And then we'll break for just a little bit, and then we'll jump over to Corey, and maybe we'll watch some testimony, get back into Corey because it's been a while now. So once again, thank you guys. Really appreciate it. And I will see you tomorrow. If it starts at 10, I'll see you at 9:45. If it starts at 11, I'll see you at 10:45. So look for us there. You can always follow us, join Patreon for free, and you'll get notifications. If you want to follow us on Blue Sky, we're on Twitter, X, we're on Facebook. And then you can also just come to our page, or just make sure that you have the notification bell highlighted and activated. And definitely don't forget to hit the like button if you have not already hit the like button. We have 242 likes, so I appreciate that, you guys. And we will see you. We'll see you tomorrow. Tomorrow's going to be Friday, last day of July 31st. So we will see you then. And in the meantime, have a great evening and do something positive for yourself. And make sure that you do something positive for yourself and for others. All right, take care, guys. Bye.